Blog Talk Radio.
Welcome, everybody to Morris Talk Live 100. I'm your host, Tarhaka LB, and tonight we're dealing with part 2 on everything I can say about business, law, illegal, and illegal. Once again, we're going to be discussing a little bit about trust. We're also going to be dealing with who and how to sue, and we're got a little bit to look at as far as the morals are concerned. So we're going to deal with that this evening as well. I want to tonight to bring out some stuff that a lot of us already know, those of us who have the materials to do so. I'll be coming to you tonight from a book called The Creature from Jekyll Island. And we will also deal with I want to deal with the fabric and the underbelly, so to speak, of the United States, its Constitution, its you know, how they do things here. Let me see, the intent of its Constitution. And I want to kind of just, you know, dig down into that a little bit, and which, in my opinion, would give us a better picture of what we're dealing with. Also, we're going to take a look at the criminal justice system when it comes to people of color inside the United States. But before we get down into all that, let me say that the chat room is open, and you all be courteous up in there. And the number to dial into the broadcast is 563-999-3443. I'm going to go to a commercial. When we come back, we'll be ready to go in. Okay? Y'all on the man.
Okay, everybody. October the 26th, right here in Duval County, Jacksonville, Florida, the Black Vegan Fest will take place. live bands, live entertainment. Professional chefs will teach you how to cook healthy. If you are a vendor, go to www.urbangeoponics.org and sign up. Bring your fishing gear with you. If you're a fisherman, we got the river right in the back of the property. We'll teach you how to grow your own food. Teach your children how to do the same thing. You'll learn how to prepare meals healthy. There'll be fun and games for the whole family. October the 26th, the Black Vegan Fest, right here in Jacksonville, Florida. Don't miss it. Make sure you got some cash with you because vendors will be on hand and they'll be selling their wares. October the 26th, the Black Vegan Fest, right here, Jacksonville, Florida. Don't miss it. Be here.
Okay. Whatever you do, be here. Once again, we did have a hurricane hit Florida. However, we are at the northern part of Florida, so it did not affect us like it did when it slammed into Tampa and other Midwestern cities down there in the state of Florida. Okay, so the Vegan Fest is still on. Okay, October the 26th, right here in Jacksonville, Florida. Yeah, hold on.
Let me make sure I got this right. You have a mortgage. You were told the bank would give you a loan for your home. But when you got to the bank, they didn't give you anything or sign anything. But presto changeo, you have a new mortgage. Then you find out your mortgage has been sold to another company you don't know and don't have any contract with. It seems to me something is wrong. When you walked out the bank, you had some papers in your hand, but no check. Let's get to the bottom, down to the bottom of this kind of stuff. Go to TarhakaDebtElimination.org. That's TarhakaDebtElimination.org. Let's bring the fraud to a close. How about that? This kind of stuff is going on all over the United States, but most people don't even understand what to do about it. TarhakaDebtElimination.org.
Okay, we're back. Before we dig down into the fabric of the United States, what I'm trying to do is give us a look at this thing from every conceivable angle. I'm a firm believer that if you know what transpired in the past and how this thing was actually put together, that will give you some keen insight to what's actually going on today. Okay, now I'm going to come to you right now from the book The Creature from Jekyll. And I'm right here on page 16 in the state right here. The story of the Bank of North America, the nation's first central bank, which was formed even before the Constitution was drafted. The story of the first bank of the United States, the nation's second central bank, which was formed in 1791. The massive inflation caused both banks the causes of their demise. Okay, now we're going to get down into that, but right now I want to just go down with what we got right here and what it states. Now it states that it is a surprising fact that the United States had its first central bank even before the Constitution was drafted. It was chartered by the Continental Congress in the spring of 1781 and opened its doors the following year. There were great expectations at that time that the province of Canada would soon join the rebel colonies to form a union extending across the entire North American continent. In anticipation of that, the new financial institution was called the Bank of North America. The bank was organized by Robert Morris, a member of Congress, who was the leader of a group of politicians and merchants who wanted the new nation to imitate the mercantilism of England. Mercantilism. That's kind of hard for me to pronounce. They wanted high taxes to support powerful centralized government, high tariffs to subsidize domestic industry, a large army and navy, and the acquisition of colonial outposts to expand into foreign lands and markets. He was a wealthy Philadelphia merchant who had profited greatly from war contracts during the Revolution. He had carefully studied the secret science of money, and by 1781 was widely considered to be a financial wizard of Congress. The Bank of North America was modeled closely after the Bank of England, following the practice of fractional reserve. It was allowed to issue paper money promissory notes in excess of actual deposits. But since some gold and silver had to be held in the vaults, there were definite limits to how far that progress could go. Banknotes were not forced on the people as legal tender for all debts, public and private. But the government did agree to accept them at their face value in payment of all taxes and duties, which made them as good as gold for that specific purpose. Furthermore, unlike the central banks of today, the Bank of North America was not given the power to directly issue the nation's money. Now I'm coming back to some more of this right here, but we're going on down in here because we want to look at the fabric of what we're dealing with here in the United States. But before we get on down in this Constitution and start looking at the underbelly of this thing, let's take a look at what the Moors have to say. That's a short take by the Moors. They ain't gonna last that long. Y'all hold on a minute. We're going.
Again, we as Moors of the Western empires, right, going all the way from the Horn, not the Horn, but from the Cape, all the way from the Ivory Coast, all the way up around into Mauritania, what is now Mauritania, Morocco, Tunis, Tripoli, Egypt, and then going all the way back down to the Ivory Coast, Cameroon, and then inside Mali. All of that was the western portion of the empire. So we here, as the Moors, have to understand that we are the torchbearers of that bloodline. Because after Granada, which one thing they don't tell you is that after the expulsion of Granada, all of the noblemen and people like that already had estates set up for them over here, because those estates was established for them over there. Because remember, it was our ancestors from northwestern and northern Africa that went up into what they now call España, set up all those dominions as far up into the southern France, what we call the Pyrenees today.
621, the word Indian was substituted for Moorish. With this single alteration, the original text was again transcribed in 1730 and 1788. However, a remarkable transformation was effected. The hat became an apron, and the official record reads, an Indian apron of long green feathers. Pronounced by a scientific authority, Dr. Fitzinger, to belong to the tribe Tavanines, the Quetzal of southern Mexico and Guatemala, restored to light by Herr von Edstetter after 23 years of oblivion. The use of the elaborate and precious piece of featherwork became the subject of thought and conjecture, resulting in recent publications of widely divergent individual opinions. Mr. T. Mailer, a resident in Mexico, traveling in Europe, saw the object in Herr von Edstedter's custody shortly after its restoration and obtained his permission to sketch it. Herr von Edstetter mentions on page 6 of his treatise his subsequent surprise at seeing him.
We, Moors, don't have anything to do with the United States government because we don't belong. We belong to the Moroccan Empire. We want to have our own separate nation, our own separate government, hospitals, towns, schools, daycares, our own police. You know, we're getting our rights violated left and right on the streets constantly Black History Month. What do they show on TV or in school? It's always so-called black people getting the hose, getting mauled by dogs. It's nothing uplifting at all. It's never, look at what you were, look at what you can be. It's always like, this is what you are and this is what you're always going to continue to be. It's a form of propaganda and brainwashing.
According to Jaleesa, the perfect storm of civil unrest, police violence, and systemic racism are attracting new members, people who are sick and tired of the status quo and frustrated at the treatment of people who look like them. What is it exactly that you all want?
Freedom, to not be oppressed, to not have life so hard to live.
Shores of Montezuma.
To the shores of Tripoli.
To the shores of Tripoli. Where's that at? Africa. Right? So you already see the connection of said empire. The first other nation to recognize the United States as its own sovereign country, if you will, was Morocco.
Yeah.
And you look at what we call the Treaty of Peace and Friendship, which is still the longest running treaty in the world.
Right now.
Right now.
Okay.
The Treaty of Peace and Friendship, signed in 1786, ratified in 1787.
What does that do for?
Got you. It's a business agreement.
Okay.
It's a business agreement for the people that left rule of Britain, that moved over here and colonized these areas. The business agreement for them to operate here under the ownership of the people that had the land.
Original Moors were the first Americans and were a matriarch society. Moorish Americans were granted permission to form themselves kingdoms in what is now Northwest Africa. Those Moorish are originally from America, aka America, and were exiled in 1492 from Spain. This is an example of the Aboriginal Moorish Americans during the early 1800s of Indiana and Illinois. If you disagree, join the live stream hosted by Supreme Leader Eli Morrow L. and challenge the information presented. Thumbs up and subscribe if you want to learn more. If you think you have what it takes and want to challenge this information, feel free to leave comment or challenge PNFSL to a formal debate. Contact IllinoisAmerican@gmail.com. If you are teaching fake history, the truth will reveal your falsehoods. Join and become a member. Subscribe, share.
So the first thing you got to do is address the disconnect. The disconnect took place in the 1400s, in the early 1500s. That's why this segment of history is important. I'm not saying that's our only history. Of course it's not. But it's the key history. Why? Because it's what cut us off from the rest of the world when it was erased.
To determine my own jurisdiction, how are you going to get that issue resolved?
Listen, this case in this courtroom is a culpable, incompetent court of jurisdiction. You can't, according to federal case law, you can't set another hearing to reach and determine your own jurisdiction. As I've stated for the record plenty of times, I'm only having threat, duress, and coercion, and because the prosecution falsely holds my property, and I'm here to clarify that matter. Other than that, I'm here under threat, duress, and coercion. It is completely against federal case law. It has power to act, and the court must have the authority to decide that question in the first instance. That's Registry Army versus Municipal Court of Los Angeles. A departure by a court from the recognized and established requirements of law, however close apparent adherence to mere form and method of procedure, which has the effect of depriving one of a constitutional right, is in excess of jurisdiction.
Moors need to keep the money in the Moorish community. Make companies, build companies, operate companies, spend the money in your community. Every other race is doing it. Why don't we do it?
A lot of the founding of America was based on Moorish science. If you see paintings of the inauguration of George Washington, it looked like a Masonic ritual. So again, Masonry is based on Moorish science. So they would have these Moorish advisors around them. If you look at old paintings of George Washington, you will see George Washington standing next to a black man with a turban. And remember, when you see the black man with the turban, that's a Moor. That's not a slave. The people automatically assume that black is slave. Slaves didn't wear no turbans because remember, slaves weren't allowed to practice no Islam or any other kind of religion except Christianity. So when you see that turban, that's a black man. And there's a few pictures of George Washington and other people with Moors or black men with turbans standing next to him.
Conquered and kicked them out the country. Well, this is what they did with the Moors. The first Africans that come here are not necessarily enslaved. These are the Moors of quality. So they enslaved them. But the confusion is one of the boats that came to America was owned by twin Moorish brothers, the Pinzon brothers. Right. P-I-N-Z-O-N, the Pinzon brothers. They owned one of the ships. Most of the captains of the Spanish fleet were black. Because who else would it have been? They learned from us. Yeah. So my thing, when I look at this story, my brother Caleb, what I try to do is to get us to understand there are waves that are happening. There is no doubt that Africans were stolen from Africa and brought to America. They are who I would call the African Americans or the American Africans that came here.
Okay, we're back, ladies and gentlemen. Now, we're going to go back down here for just another minute because I'm trying to give you some backdrop. Now, you know, one brother said the Moors and their money need to be where it need to be. Well, let's find out what we're dealing with when we're talking about more or dollars and money in the United States. It says function as a central bank. On the other hand, the bank was given the right of monopoly in its field, which means there were no other banknotes allowed to circulate in competition. This plus the fact that they were accepted at face value in payment of all federal and state taxes. Now, you see what this is saying? Plus the further fact that the federal government did not, at that time, have a functioning money of its own, made these banknotes attractive for use as a circulating medium of exchange. The intended result was that the bank's paper would be accepted as money, which for a while it was. Furthermore, the bank was made of the official depository for all federal funds, and it almost immediately loaned $1.2 million to the government, much of which was created out of nothing for that purpose. So in spite of the limitations placed upon the bank, and in spite of the fact that it was essentially a private institution, it was intended to be, and in fact did function as a central bank. The Bank of North America was fraudulent from the very start. The charter required that private investors provide $400,000 for the initial subscription. When Morris was unable to raise that money, he used his political influence to make up the shortfall out of government funds in a maneuver that was nothing less than legalized embezzlement. He took the gold that had been loaned to the United States from France and had it deposited in the bank. Then, using this as a fractional reserve base, he simply created the money that was needed for the subscription and loaned it to himself and his associates. Such is the power of secret science. It is hard to reconcile the fact that the same men who adopted the brilliant monetary restraints of the Constitution a few years later would have allowed the Bank of North America to exist. It must be remembered, however, that the war was still in progress when the charter was issued, and even the wisest of statesmen are often obliged to follow expediency in such times. One almost must conclude that while the founding fathers were wise on the nature of fiat money created by the government's printing press, they had not yet had extensive experience with the same mechanism hidden behind the obscurities of fractional reserve banking. In any event, the bank was not to have its charter renewed by Congress and it did not survive beyond the end of the war. Murray Rothbard details its demise. We're going to get down into that in a minute, but we're going to move forward. And let's take a look at this the Constitution here for a minute. Okay, the original intent of the Constitution. Let's take a look at that. We got the backdrop now. We just found out what happened with the first bank, because I got it in this book. I forgot exactly who said it, but it says, "Let me control the money, and I don't care who writes the laws of the country. Just let me handle the money." Okay. All right, y'all hold on a minute.
There's a great deal of talk today about the original intent of the writers of the Constitution. Now, no matter where one stands on that issue, it is important to realize that the writers of the Constitution did not foresee or plan to create the political system that we have today. That is, a democratic republic based upon two national and permanent political parties. Indeed, democracy and political parties were dirty words to them. Nor did the writers anticipate the economic system we have today or our social values. In many, if not most ways, the world they lived in was very different from the one we live in. They realized that their world was likely to change. That's one of the reasons they put into the Constitution the amendment process, which in turn is one of the major reasons this document has survived as our frame of government for so long, and despite all the changes in all aspects of American life. Now, to understand the world of the founders, we must first understand who they were, the problems they faced, and why they created this new frame of government. We also need to understand the historical controversies that have swirled around them and exactly what is in the document that they created. The public lack of knowledge of those contents is frightening. A survey conducted during the 1987 bicentennial showed 46% not knowing the original purpose of the Constitution. 26% thought it was to declare independence from England. 59% did not know what the Bill of Rights was. Only 41% correctly identified it as the first 10 amendments. 27% thought it was the preamble to the Constitution. And a frightening 49% erroneously thought the president could suspend the Constitution. Let's begin with the world of 1787 and the ensuing historical controversies. The Constitution was not the original frame of government of the newly independent United States. The states originally were governed by the Second Continental Congress, and then from 1781 to 1789 by the Articles of Confederation. Now, late 19th century historians saw these articles as a disastrous failure, and indeed called this time period the critical period, where an infant and endangered United States was saved by the godlike founding fathers. That interpretation was stood on its head in the early 20th century by historians such as Charles Beard, who argued that it was not a critical period, but that its democratic thrust alienated the moderates of the previous decade, the revolutionary decade, who had become reluctant revolutionaries. Motivated by economic and class interests, they responded with the Constitution as an anti-democratic, counter-revolutionary document in an effort to protect those interests. Now, that interpretation itself then came under attack in the mid and late 20th century. This, as we will see in later lectures, is part of the ongoing process of historical interpretation and reinterpretation. For now, let me just note that many historians today view the Constitution as a continuation of the Revolution, not the antithesis of the Revolution. Also, the issue is far from settled, and it is unlikely ever to be settled. For historical interpretations, again as we will explore in later lectures, are constantly being affected and revised by present-day concerns. My interpretation that follows will thus reflect contemporary scholarship and contemporary issues and values. Now, the process of creating governments began in the 1770s as the colonial assemblies transformed themselves into state legislatures and governments. This process would involve a series of major departures from British practice, reflecting colonial experiences. For example, the colonists rejected the British concept of balanced government in favor of overwhelming legislative power. The colonial governors and judges had been royal appointees and had been perceived as tyrannical. In the Articles of Confederation period, their powers were extremely limited within each state. You also had a move to written constitutions within each state instead of unwritten constitutions. This was due to the perceived failure of the unwritten British Constitution to protect liberty. You also had an old tradition in colonial history of written charters in the founding of many colonies. State assemblies became more representative due to the logic of the revolution, as I explained in the last lecture, with the franchise extended and frequent elections. The central government, at first, was the Second Continental Congress, which was obviously makeshift, and it was replaced by the Articles of Confederation, which were presented to the states in 1777, but not ratified by all the states until 1781. Why? The states retained their distrust of any centralized power. That's what they were fighting against. And they also retained their distrust of each other. There had been no history of cooperation before the revolution, and the cooperation that existed during the revolutionary period had been quite limited and broke down once the revolution ended. Smaller states fear larger ones, especially those with Western land claims, for fear that they, the small states, would lose their population to larger states that could avoid taxing by simply using land sales to run the government. Maryland, for example, refused to ratify the Articles of Confederation unless state Western land claims were given to the national government. Virginia and other states agreed in order to get a central government, and because they believed that a Republican form of government could not work in large areas. This is something I'll get to later. Now, the Articles did set up a central government of sorts, but a very weak one. There was no executive, no judiciary, only a Congress with no power to tax or to do anything important without a vote of 9 out of the 13 states. Nor could they change the structure without a unanimous vote in favor of changing it. Each state had one vote, and thus a virtual veto power. This had all been done very consciously. The states saw themselves as independent republics, retaining sovereignty and joining into a loose confederation, similar to today's United Nations. This came from their colonial past, in addition to their fear of centralized power from the revolutionary era. Liberty was now to be guaranteed by decentralization and by state legislatures. Now, despite the inherent weaknesses obvious of this frame of government, much was actually accomplished under the Articles. The winning of independence and the obtaining of a favorable peace treaty in 1783 with a western boundary all the way to the Mississippi River. The establishment of state governments with many social and political reforms. The lowering of property qualifications for voting to extend the franchise. Frequent elections. Separation of church and state. Beginning of the abolition of slavery in northern states. Expansion of education and literacy. And the creation of state bills of rights. You also established the pattern for Western expansion and settlement with the Northwest Ordinances of 1784, 85, and 87. All Western land north of the Ohio River that had been given up by the states to the national government was to be surveyed, divided, and sold in 640-acre lots for $1 per acre. Eventually, there would be self-rule and admission to the Union as anywhere from 3 to 5 new states on an equal basis when the population had reached 60,000. There were also guarantees of freedom of worship, trial by jury, and there was to be no slavery in this entire territory. Internationally, trade was opened with the European powers under the Articles of Confederation and with Asia, and loans were extended to the United States. But the problems under the Articles appeared to many to outweigh these successes by 1787, and those problems were both external and domestic. The Confederation Congress had no power to tax, and thus no power to pay for an armed force or to pay its debts. After the Revolution, the Navy was sold. At one point, the Army was down to 80 men. Rather than a national army, reliance was placed on untrained and unreliable state militia. Now, this lack of military power, lack of power to tax, translated into no power in foreign affairs and no respect from the European powers. The British locked the United States out of their mercantilist trading system. They also violated the peace treaty by refusing to leave their posts in the Northwest, and they supported, in fact incited, Indian resistance from those posts to American settlers. Nor was that the end of it. Spain refused to agree to the southern U.S. boundary with Florida and denied the United States the right to navigate the Mississippi River and the right of deposit at New Orleans. It also incited secessionist movements in the Southwest. Internally, there is a post-war economic depression blamed on the Articles. People in each state demand relief. The easiest way to obtain relief is to stop foreclosures on land for non-payment of debts, to repudiate debts, and or to print paper money so as to create inflation, which will make repayment of debts much easier. That is easy to do since there's little or no check on legislative powers in each state. And creditors and men of property complain that the state governments are breaking the social contract by doing this, and that this is, as we would say today, democracy run amok. States are establishing their own currencies and trading systems. There is a breakdown in interstate relations with the looming danger of states turning to European allies and thus opening the door to European intervention, manipulation, and control. By 1786-87, there is fear of anarchy with Shays' Rebellion in western Massachusetts. Daniel Shays, Revolutionary War hero, led a march of 1,200 on the courts to stop foreclosures and then on the Springfield Arsenal to obtain weapons. There was no national army to stop this. The state militia did, but they could just as easily have failed due to lack of training or even joined Shays' men. And after Shays' defeat, his followers were elected to office and stopped foreclosures anyway. What all of this illustrated was the weakness of both the state governments and the national government. Now, all of this convinced many that the present national government was incapable of defending the liberty won during the Revolution and that a new frame of government was necessary. What you have here, one needs to realize, is an elite definition of liberty. It is not democracy at all. It is individual freedom from tyranny or from any form of external control or interference. But, by the political thought of the day, such tyranny or control could come from above or from below, from mob rule that broke the social contract. John Randolph of Virginia, I think, summed this up best in his famous quote, "I am an aristocrat. I love liberty. I hate equality." Now, while the revolution has fought successfully for liberty and against tyranny from above, liberty to these men is now threatened by tyranny from below. Simultaneously, It is once again threatened by tyranny from above as well, the danger of European intervention and the destruction of the entire Republican experiment. More centralized power is thus perceived as necessary to fend off the Europeans and their tyranny from above and the tyranny from below that would come from democratic mob rule. By 1786, those who think this way find support amongst the middle and lower classes as well as the upper classes. Creditors, of course, merchants and shippers who want a national commercial policy and power to break into the European mercantilist trading systems. Artisans who want a high national tariff. Westerners who want defense against the Indians, the British, and the Spanish. Land speculators wanting the same, as well as protection from squatters. In 1786, representatives from 5 states met in Annapolis and asked Congress to call a special convention to revise and strengthen the Articles of Confederation. That would lead to the Constitutional Convention. 55 men from 12 states gathered in Philadelphia from May to September 1787. Well, who are they? It's interesting to note who is not in Philadelphia. Such revolutionary radicals as Patrick Henry, Sam Adams, Thomas Jefferson, they are not there. The revolutionary leaders Franklin and Washington are present. But aside from these two venerable figures, most of the delegates are quite young. James Madison and Gouverneur Morris are only 35. Rufus King and Alexander Hamilton are only 32. Charles Pinckney is only 29. Almost all had continental as opposed to state experiences during the Revolutionary War. Many were veterans of Washington's Continental Army or the Continental Congress, and that experience gave them a national as opposed to a state outlook. At least one historian has labeled them the first true Americans. Now, are they conservative or revolutionary? They are simultaneously both. They are conservative as men of property who fear democracy and mob rule as destructive of liberty. They are elitist Republicans, if you will, rather than democratic Republicans. But simultaneously, they are revolutionary in their desire to create something new, a large republic with centralized power that preserves liberty rather than destroying it. One needs to understand that this contradicts established political thought and experience. That established political thought and experience held that republics only worked in small areas and that large centralized nations were best ruled by absolute monarchs. The founders would turn this on its head. And what you get here, one might argue, is a concept of creating an empire of liberty. The men who gather in Philadelphia were also willing to ignore their instructions to revise and amend the Articles of Confederation, and instead they decided to come up with an entirely new frame of government, one that they devised in secret sessions with locked doors and windows, despite the summer heat. One can argue that in some ways what you had here was a coup. The basic dilemma: how do you create a government strong enough to preserve liberty from tyranny of the mob and or from the European monarchs without giving it enough power to be tyrannical itself? This dilemma was best expressed by the father of the Constitution, James Madison, later when he wrote the 51st Federalist Paper. If men were angels, Madison wrote, no government would be necessary. If angels were to govern men, neither external nor internal controls would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people is, Madison continued, no doubt the primary control on government. but experience has taught mankind the necessity of auxiliary precautions. The Constitution thus begins with "we the people." Sovereignty rests with the people. But the document then separates sovereignty from rule via a series of intermediaries, and it divides power between those intermediaries so as to avoid tyranny. We know the system is checks and balances, and it exists on two levels: the separation of powers between the three branches of the new national government, and the division of powers between that new national government and the existing state governments. Let's look at the separation of powers first. The founders returned to the concept of balanced government due to the perceived excesses and weaknesses of the existing legislative governments. What they decided to do was to combine elements of monarchy, aristocracy, and democracy within the new national government. Let's look at the president. The president is a monarch, the executive power, but one indirectly elected via the Electoral College. And it was perceived at that time that the electors in the Electoral College would be the aristocrats. Furthermore, the president's term is limited to 4 years, and the powers of the presidency are limited to those enumerated in Article 2 of the Constitution. The Senate is an aristocratic branch of government. It is not directly elected by the people, not in the original Constitution. You needed a constitutional amendment to change that. It is done via the state legislatures. One might argue that the people elect senators indirectly. They vote for their betters in the state legislatures, and the state legislatures determine who will be the senators. The term is lengthy, 6 years, with the powers listed in Article 1 of the Constitution. The national judiciary is also aristocratic. The Democratic branch is to be the House of Representatives, with short terms, frequent elections, but still you have property qualifications for voting. The theory at the time was that you had to have a stake in society in order to be able to vote. Each branch had the power to check the other branches. For example, the president is the commander-in-chief, but Congress appropriates funds for the armed forces and declares war. The president makes judicial and diplomatic appointments and negotiates treaties, but with the, quote, advice and consent of the Senate and appropriations approved by both houses. Congress makes the laws, but the president can veto them, and the Congress can override the veto with a 2/3 vote. So much for the separation of powers. What about the division of powers? The new national government has enormous power, but does not have a monopoly on power. It is to be shared with the existing state governments, and that is explicitly reaffirmed in the 10th Amendment, which states that all powers not delegated to the new national government or prohibited by it to the states are reserved to the states, so that the states can be capable of checking the national government, as the national government can be capable of checking the excesses of the state. Some powers are very clearly shared. State militia are controlled by the state governments unless called into service by the president, to active service for the national government by the president. The document sets up a very large republic. And as I pointed out before, in theory, by political theory of the day, it cannot survive. Madison, in the 10th Federalist paper, turns this established political theory on its head. He claims that a republic in a large area has a better chance of preserving liberty than a republic in a small area. And in the process, he explains the logic behind the entire system. Madison defines factions as the key problem, and factions as a minority or a majority willing to ride roughshod over the rights of others to ensure its own interests. In democracies, a majority faction can easily gain control and destroy liberty. Now, Madison insists that such factions cannot be abolished without abolishing liberty. They are inherent in human nature. The key is to control them, and that is to be done via checks and balances. Madison then argues that a large republic can do this better than small republics because the greater the population and area, the more factions will exist, and thus the less chance of one faction dominating over the others. As Madison noted in this regard, a major difference between a republic and a democracy was the greater number of citizens and the extent of territory that could exist under a Republican government. The smaller the society, Madison wrote, the fewer probably will be the distinct parties and interests composing it. The fewer the distinct parties and interests, the more frequently will a majority be found of the same party, and the smaller the number of individuals composing a majority, and the smaller the compass within which they are placed, the more easily will they concert and execute their plans of oppression. That's for small democratic society. As for republics, extend the sphere, and you take in a greater variety of parties and interests, you make it less probable that a majority of the whole will have a common motive to invade the rights of other citizens. Or if such a common motive exists, it will be more difficult for all who feel it to discover their own strength and to act in unison with each other. Now, despite agreement on such essentials, disagreements among the delegates almost wrecked the convention. Major disputes pit large against small states, northern against southern states. Delegates also split over just how much power to give to the national government at the expense of the states. The large versus small state dispute focuses on representation in Congress. Madison's Virginia plan had called for representation in both houses of Congress to be based on population. Small states like New Jersey refused to agree. The result was the so-called Great Compromise. The House of Representatives would be based on population, but there would be equal representation for all states in the Senate. There is also a split between the commercial and urban North, as opposed to the agrarian and slaveholding South. That split was already apparent, and it led to a series of compromises. There would never be an export tax, because the South produced the cash crop. There would be no ban on the slave trade for 20 years. A 2/3 vote would be needed in the Senate on all treaties, and a slave was to count as 3/5 of a person for purposes of representation and taxation. Now, some delegates feared that despite the checks and balances, this new national government had too much power. Only 39 of the 55 who were in attendance signed the final document. But the majority believed they had come up with something superior and unique, a large, centralized republic capable of acting strongly while preserving liberty. But will their fellow citizens agree? The document called for special state ratifying conventions in each state, with 9 states needed to put the document into effect. Intense opposition emerged in virtually every state, primarily from established groups who control state governments and fear such centralized power. The result would be a major struggle in each state. It was very close, especially in the critical states of Virginia and New York. The Federalist Papers, I quoted, were written not only by Madison, but also by Alexander Hamilton and John Jay in an effort to convince New York voters to accept the Constitution. The pro-Constitution forces won for a host of reasons. They were better organized, they were on the offensive, and they had the advantage of defining themselves as Federalists. Really, they were nationalists. But by taking the title Federalists, what could their opponents call themselves? Anti-Federalists? That was quite a negative connotation. Also, the call for ratification via state conventions, special state conventions, meant that the state legislatures, which had a vested interest in the failure of the new system, would be bypassed. Furthermore, the Federalists agreed to a key anti-Federalist objection, the lack of any specific Bill of Rights. They agreed to create one as their first order of business under the new government. The result would be the first 10 amendments to the Constitution. North Carolina and Rhode Island did not agree until 1790-91, but the rest did agree early enough for the new government to begin functioning in 1789. So what do we have here? The final document in the Federalist Papers show the founders as Hobbesian realists who distrusted human nature and who sought to stop what they considered the excesses of the Revolution. In that sense, they could be considered conservative and even counter-revolutionary. Simultaneously, however, they are still Lockeans and revolutionaries who wish to preserve their Republican experiment against what they consider clear and present dangers. And they are willing to try a radical, unprecedented experiment to do so. The only analogy they have for a large republic is Rome, and that is not a very reassuring one. They see their Constitution as fulfilling, not negating, the ideas of the Declaration of Independence, a way to make republicanism work and thereby allow liberty to thrive. Now, they succeed in establishing a new frame of government, but in the process, they left a series of unanswered questions for the future. Is this a union of the people, as the House shows, or of the states, as the Senate shows? What is the proper balance between state and national power? How can you have a Republican empire of liberty when that liberty is based on the enslavement of others? Counting slaves as 3/5 of a human being does not really answer that question. And can you really have an empire of liberty, a large expanding nation, run by a central government powerful enough to retain domestic order and military security without creating a tyranny from above? Within a few years, the writers of this document will split on their answers to these questions. They will fail to resolve them in their lifetimes. They will change the system they created in trying to solve them, and they will bequeath those problems to their successors. And while some of those problems would be resolved in the 19th century, be it by compromise or by civil war, others remain central to our political discourse throughout the 20th century and still today. Most notably, the proper balance between state and national power. And some would argue whether it is indeed possible to have an empire of liberty.
Okay, we're back, everybody. I hope that gave us a little bit of insight of the past underbelly of the United States and how it is constructed where we are today. So what I'm going to do now is I'm going to take a little quick commercial break, and when we come back, I'm going to conclude this thing about our first bank in the America. Okay? So y'all hold on a minute, and we will be right back.
If it is against the law for the bank to loan out depositors' money to you, how could the bank give you a loan? And if that's the case, how are they able to keep their doors open? And in some cities, they have the biggest buildings in town. What happens to the person who deposits money in the bank? What do they receive outside of nickels and dimes in the form of what's called interest? How can you get paid? Go to TarhakaDebtElimination.org. That's TarhakaDebtElimination.org. Fill out the Contact Us form, and I'll rush you my free report. Let's get down to the bottom of this situation. Let me show you what's going on and how to deal with it. Okay, TarhakaDebtElimination.org. Peace, y'all.
Okay, we back. Now, in conclusion, it states, despite the monopoly privileges conferred upon the Bank of North America and its nominal redeemability in specie, the market's lack of confidence in the inflated notes led to their depreciation outside the bank's home base in Philadelphia. The bank even tried to bolster the value of its notes by hiring people to urge redeemers of its notes not to insist on specie, a move scarcely calculated to improve the long-run confidence in the bank. After a year of operation, Morris's political power slipped, and he moved quickly to shift the Bank of North America from central bank to a purely commercial bank, chartered by the state of Pennsylvania. By the end of 1783, the first experiment with the central bank in the United States had ended. A fitting epilogue to this story was written 200 years later when, in 1980, the first Pennsylvania Bank of Philadelphia, the oldest bank in the nation, was bailed out by the FDIC. We're going to stop right there. So now we see this is consistent with what we have already understood about what took place in the past with the government of the United States and the banks and stuff. And the bank part of this is just separate because I wanted to get you to take a look at how this life is the way it is and what led us up until this point here. And the first financial institutions and what happened to them using the currency that we have today and printing money out of thin air, no gold back and all that, and getting down and all that like we always do. But now let's move forward now that we've gotten that under our belt. And let's deal with the situation in the United States about the 8 facts about the Second Amendment. Okay, we want to deal with 8 facts about it. Okay? Y'all hold on a minute.
The Second Amendment has ignited a firestorm of debate like no other in the Bill of Rights. In this video, we'll unpack some of its history and controversy. But let's start here. The grammar on the amendment is a train wreck. I mean, by dedicating one of the initial 10 amendments to guns, clearly the Founding Fathers thought this was an important fundamental right. But the sentence is just not well written. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. That's at least 1 comma too many, and it goes in reverse order of importance. As an article in The Economist concluded, it is hard to believe the framers would be happy with the result of their work. America remains bitterly divided over guns thanks to a bizarrely worded amendment that has not stood the test of time. Yeah, if the goal was to write a simple, clear sentence that would be understood for hundreds, if not thousands of years, I'm giving James Madison like a D-. But it does raise the question, how did everything that happened in America's early days, from the Intolerable Acts, to the Revolutionary War, to the Articles of Confederation, to the Federalist Papers, build up to that exact sentence? We'll cover all that and more through the following 8 facts about the Second Amendment. Fact number 1, the roots of the Second Amendment can be traced to the English Bill of Rights of 1689. The English Bill of Rights holds an elevated stature in legal history, perhaps only behind the Magna Carta. To this day, it's a crucial statute in English constitutional law. This document establishes basic civil rights and clarifies the line of succession for the Crown. It also lays out a constitutional requirement for the Crown to seek the consent of the people, as represented in Parliament. It's largely influenced by the ideas of John Locke, as of course were the American Founding Fathers, so it's no surprise that the Second Amendment would have its roots in the English Bill of Rights, which declared that Protestant citizens may have arms for their defense suitable to their conditions and as allowed by law. That provision was likely the result of the English Crown's attempts to use militias to control and disarm dissidents prior to the Glorious Revolution that removed King James II in favor of William and Mary. In her book, To Keep and Bear Arms, The Origins of an Anglo-American Right, historian Joyce Lee Malcolm argued that the right of the English population to privately hold arms was born in 1689. She asserted that Article 7 of the English Bill of Rights entrenched an individual's private right, as opposed to the right of a collective militia, as part of British constitutional law. This video is brought to you by Students for Liberty, an international non-profit organization focused on building a global network of elite young leaders passionate about liberty. Students for Liberty's coordinator program, designed for university students and recent graduates, is engineered to help you unleash your potential by providing you with the tools, training, and resources that you need to build a freer future. To apply or to learn more, see the link in the video description or visit studentsforliberty.org. Fact 2. The Second Amendment also has its roots in state constitutions. The Bill of Rights, of course, was ratified in 1791, but check out the Pennsylvania Declaration of Rights from 15 years earlier. That the people have a right to bear arms for the defense of themselves and the state. Vermont's Constitution, enacted in 1777, said the people have a right to bear arms for the defense of themselves and the state. Finally, here's the Massachusetts Declaration of Rights of 1780. The people have a right to keep and to bear arms for the common defense. Notice what those wordings have in common that's different from the final version of the Second Amendment? In all of those state constitutions, the language about the right to keep and bear arms comes first. These state constitutions reflect the reality that in founding-era America, citizen militias existed to provide defense against the possibility of an invasion from, well, the British, yes, but also from aggression on the part of the federal government. Standing armies of professional soldiers, like what we have nowadays in the Navy, Army, Air Force, and so on, were viewed with deep skepticism, and in fact viewed as unnecessary, provided the citizenry could arm itself. Indeed, in Federalist 46, James Madison argued that state governments with militias of the people on their side would suffice to counterbalance a federally controlled regular army, even one with the full resources of the country. And it makes sense to prefer a decentralized power structure. Think about it. Nowadays, the target for an invading foreign army or a rogue general would be obvious: the government buildings in Washington, D.C. But if power and authority were thoroughly decentralized, armed militias scattered throughout the country from state capitals to cities to small towns without even a central registry or official list of who's a member, where and whom would an invading army attack? New York City? Ashtabula, Ohio? Last Chance, Iowa? That's why classical liberals have long pushed for decentralization as a measure of enhanced security. Even if you eliminate one branch of a decentralized network of militias, it would be like chopping off the leg of a starfish. A new leg would regenerate, and so a foreign invader would forever be playing whack-a-mole. Fact number 3. The Second Amendment went through several drafts. We covered the various state constitutions: Pennsylvania in 1776, Vermont in 1777, and Massachusetts in 1780. But as it turns out, Madison himself produced an initial draft of the Second Amendment in 1789. It's in the Annals of Congress and reads like this. Notice, again, the right to keep and bear arms comes first. The right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free country. But no person religiously scrupulous of bearing arms shall be compelled to render military service in person. To me, that initial draft is actually a lot better. It begins with the operative clause, which is the clearest, most important statement. The right of the people to keep and bear arms shall not be infringed. But Madison would revise the amendment, reordering the first two clauses and ultimately inviting the possibility for different interpretations. His next draft would be resolved by the House of Representatives on August 24, 1789, and sent to the Senate. It said, "A well-regulated militia composed of the body of the people, being the best security of a free state, the right of the people to keep and bear arms shall not be infringed. But no one religiously scrupulous of bearing arms shall be compelled to render military service in person." The amendment took its final shape in the Senate, where the religious objector clause was removed and several other phrases were modified. For instance, the phrase referencing the militia as composed of the body of the people was taken out, and the description of the militia as the best security of a free state was modified to necessary to the security of a free state. Other changes were proposed and rejected, including limitations on a standing army in times of peace and the phrase "for the common defense" next to the words "bear arms." The final language of the Second Amendment was agreed to and transmitted to the states in late September of 1789. Fact 4. The Second Amendment has a prefatory or preface clause and an operative clause. So let's take a closer look at that final language. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It's the only amendment in the Bill of Rights that has a preface before the actual substance of the amendment. The prefatory clause is a big part of the modern controversy, confusion, and legal interpretation. Look no further than District of Columbia v. Heller, the 2008 case in which the Supreme Court recognized that the Second Amendment protects an individual right to arms, that essentially the government can't enforce laws that prevent Americans from possessing commonly used weapons in their home for self-defense. But it was the prefatory clause that gave the dissenting Supreme Court justices their ammunition. They argued that the Second Amendment never guaranteed an individual right at all. Their argument is based on the reference to a well-regulated militia, which they define as a military force organized and supervised by the government. Being part of a well-regulated militia, the prefatory clause, can conceivably be interpreted by proponents of gun control as the only reason that the right to keep and bear arms exists, instead of just one of the reasons. But that argument falters in light of the very purpose for bills of rights throughout the world, from the English Bill of Rights to France's Declaration of the Rights of Man and the Citizen, to the United Nations Universal Declaration of Human Rights. Their main goal is to preserve and guarantee individual rights. As George Mason University law professor Nelson Lund put it, no one thinks that when the First Amendment speaks about the right of the people to petition the government, that it means only to protect the rights of lobbyists for state governments. It means individuals. What the Second Amendment is saying is you can't disarm the people under the pretext of regulating the militia. Moreover, the majority opinion in the Heller case, written by Justice Antonin Scalia, argues compellingly that it would make no sense to read the prefatory clause in the way the dissenting judges interpreted it, because that reading would render the operative clause moot, not to mention redundant. As Reason magazine said, when the words "the right of the people" are used elsewhere in the Bill of Rights, in the First and Fourth Amendments, for example, it plainly means a right that belongs to every individual, as opposed to a collective with special properties, such as a militia. Fact 5. History has not looked kindly upon previous attempts to regulate guns. In 1865, on the heels of the Civil War, many southern states passed a series of laws known as the Black Codes, or the Black Laws. These laws restricted the rights of African Americans to own property, conduct business, buy and lease land, and move freely through public spaces. A main feature of the Black Codes was the outlawing of vagrancy, which allowed local authorities to arrest people, you can guess which race, for minor infractions and commit them to involuntary labor. But baked right into the Black Codes, of course, was a restriction on African Americans' right to own and possess firearms. With the passage of the Black Codes, it became a crime for a black person to have a gun. The Harvard Law Review wrote, "For a significant portion of American history, gun laws bore the ugly taint of racism." The Atlanta Voice, a weekly African-American community newspaper, opined, "Gun control historically has meant prohibiting blacks from owning one." Should we trust the same governing bodies and processes that passed those laws under the guise of protecting public safety to pass fair and moral laws nowadays? I sure don't. Especially since, as NBC News reported, the sales of guns to black Americans rose 58% in 2020. And that trend appears to be continuing as we move deeper into the 2020s. Rule of thumb. Laws and regulations generally have less of an effect on the wealthy and the privileged, who can afford whatever legal curveballs are thrown their way, compared to the effect on the less fortunate, poor folks, minorities, immigrants, who can't. Keep that in mind the next time someone talks to you about common sense gun control. Fact 6. The two major political parties used to be flipped on the interpretation and implementation of the Second Amendment. Oh, how quickly we forget. It wasn't that long ago that Democrats were pro-gun rights while their Republican counterparts were less gun-ho. The seminal moment took place on May 2nd, 1967, when 24 armed members of the Black Panther Party stormed the California State Capitol in Sacramento. As Mark Twain once said, history doesn't repeat itself, but it often rhymes. The Black Panthers were protesting the Mulford Bill. When Governor Ronald Reagan, a Republican, signed the bill into law a few months later, it prohibited the carrying of a loaded firearm on one's person or in a vehicle while in any public place or on any public street in a prohibited area of unincorporated territory except for specified law enforcement officers, military personnel, bank guards and messengers, sportsmen, private investigators, and patrol operators, and persons authorized to carry concealable weapons. When the protesters arrived at the Capitol, Reagan was hosting a group of 8th graders on the Capitol lawn. He was quickly hustled inside. The protesters were ushered away by state police who confiscated the weapons despite the Panthers' argument that they could legally carry the weapons as long as they were not concealed. The Mulford Bill, still part of the California Penal Code, was supported by the National Rifle Association. Upon signing it, Reagan said, "There's no reason why on the street today a citizen should be carrying a loaded weapon." History doesn't repeat itself, but it often rhymes. And when it comes to gun rights and the Second Amendment, history totally rhymes, but with the parties flipped. Once upon a time, when it suited their whims, Democrats were pro-gun. Once upon a time, when it suited their whims, Republicans were anti-gun. But know who's never flipped? Classical liberals and the principled pro-liberty movement in general. We haven't wavered or changed our messaging on this issue. We've always defended the individual's right to own guns, and we always will. And by the way, if you feel inspired by the ideas in this video and want to take action, visit studentsforliberty.org. Fact 7. There was another attack on the Second Amendment in 1994. Within the Violent Crime Control and Law Enforcement Act signed by Bill Clinton in 1994 was a subsection called the Public Safety and Recreational Firearms Use Protection Act. This is what came to be known as the assault weapons ban because it outlawed the ability to manufacture, transfer, or possess a semi-automatic assault weapon. 19 military-style or copycat assault weapons, including AR-15s, could no longer be manufactured or sold. It also banned certain high-capacity ammunition magazines of more than 10 rounds. But it came with a big unless. Unless, it continued, that weapon was lawfully possessed under federal law on the date of the enactment of this subsection. That date, September 13th, 1994. That little caveat represents what's known as grandfathering, and it's another way lawmakers protect the wealthy, the connected, and the privileged over and above the disadvantaged. Guns are expensive, of course, so this provision of the bill is like saying you must be this tall to get on this ride, except it was you must be this rich by this date if you want to own a semi-automatic assault weapon. It's a method of systematically prioritizing the interests of the wealthy over the interests of everyone else. Because remember, when a ban is enacted, it doesn't magically destroy all of the banned thing. What it does do is restrict access of that thing to the most powerful, most wealthy, and most well-connected people. Luckily, this so-called assault weapons ban was temporary. The bill stipulated it would last only 10 years, although since it expired in 2004, there have been multiple failed attempts to renew the ban. Fact 8. American police are increasingly militarized. Okay, so this isn't really a fact about the Second Amendment, but it does make the Second Amendment just as important now, if not more so, as when it was written. As someone who used to be pro-gun control, this is an argument I trotted out all the time. Sure, in the days when there were roving British soldiers during the Revolutionary War and all, citizens might have needed guns, but those days are long gone. What I didn't understand was that today's police officers are, in many ways, the equivalent of yesteryear's British soldiers. Like the British soldiers, they roam the streets with an undeserved air of authority, enforcing laws many of us find reprehensible, their uniforms and weapons funded by the involuntary collection of taxes. And as we saw during, for example, the riots in Ferguson, Missouri, those weapons are absurdly powerful. We're talking stuff that was used by the military during the invasions of Iraq and Afghanistan. The ability of each and every citizen, not just the rich, not just those with friends in Congress, not just those already well off enough to own a gun, to acquire and own a gun, is a check on those police, who, as we've seen time and time again, have the tendency to abuse their authority. So there are 8 facts about the Second Amendment, a contentious and poorly written amendment with a checkered history, but a crucially important one nonetheless. Which did you find the most interesting? Answer in the comments, and while you're at it, consider one further question. What comes first, rights or government? I mean, is it the government's responsibility to provide a Bill of Rights in the first place? Must it be the government that provides the right of the people to keep and bear arms? Because if the government giveth, does that mean the government can taketh away?
All right, everybody, we're back. I just thought it was very, very important for us to look at the underbelly of certain aspects of what we're calling law inside the United States. And now we're going to go down here, and we got 2 things to cover that I definitely want to cover. I want American law, and I also want to cover the criminal justice system from a different angle and a different perspective. But y'all hold on a minute, and we will be right back. Hold on.
You will not be able to stay home, brother. You will not be able to plug in, turn on, and cop out. You will not be able to lose yourself on Skag and skip out for beer during commercials because the revolution will not be televised. The revolution will not be televised. The revolution will not be brought to you by Xerox in 4 parts without commercial interruptions. The revolution will not show you pictures of Nixon blowing a bugle and leading a charge by John Mitchell, General Abrams, and Spyro Agnew to eat hog maws confiscated from a Harlem sanctuary. The revolution will not be televised. The revolution will not be brought to you by the Schaefer Award Theater and will not star Natalie Woods and Steve McQueen or Bullwinkle and Julia. The revolution will not give your mouth sex appeal. The revolution will not get rid of the nub. The revolution will not make you look 5 pounds thinner because the revolution will not be televised, brother. There will be no pictures of you and Willie Mae pushing that shopping cart down the block on the dead run or trying to slide that color TV into a stolen ambulance. NBC will not be able to predict the winner at 8:32 on report from 29 districts. The revolution will not be televised. There will be no pictures of pigs shooting down brothers on the instant replay. There will be no pictures of pigs shooting down brothers on the instant replay. There will be no pictures of Whitney Young being run out of Harlem on a rail with a brand new process. There will be no slow motion or still life of Roy Wilkins strolling through Watts in a red, black, and green liberation jumpsuit that he has been saving for just the proper occasion. Green Acres, Beverly Hillbillies, and Hooterville Junction will no longer be so damn relevant, and women will not care if Dick finally got down with Jane on Search for Tomorrow, because black people will be in the street looking for a brighter day. The revolution will not be televised. There will be no highlights on the 11 o'clock news and no pictures of Harry armed women liberationists and Jackie Onassis blowing her nose. The theme song will not be written by Jim Webb or Francis Scott Key, nor sung by Glenn Campbell, Tom Jones, Johnny Cash, Engelbert Humperdinck, or The Rare Earth. The revolution will not be televised. The revolution will not be right back after a message about a white tornado, white lightning, or white people. You will not have to worry about a dove in your bedroom, the tiger in your tank, or the giant in your toilet bowl. The revolution will not go better with Coke. The revolution will not fight germs that may cause bad breath. The revolution will put you in the driver's seat. The revolution will not be televised, will not be televised, will not be televised, will not be televised. The revolution will be no rerun, brothers. The revolution will be live.
Blacks commit more crimes than whites do.
Okay, well, first of all, what he means by blacks commit more crimes is, in fact, that African Americans are more often convicted of committing crimes in the United States than any other racial demographic, which is very different from what he said. All that indicates is that the so-called criminal justice system in the United States is primarily only effective in the selective investigation, prosecution, and conviction of African Americans and other so-called minorities, as opposed to investigating, prosecuting, and convicting white perpetrators. The statistics that he's citing are actually an evidence arguing racial bias in policing, in prosecution, and in trials. It's not an evidence of greater criminality along racial demographic lines, no. Rather, it's only the assignment of criminality that falls along racial lines. I mean, more than half of all violent crimes in the United States go unsolved, overwhelmingly the case in certain types of violent crimes. So we're not talking actually about a criminal justice system that works, that's actually effective, that's actually efficient, that actually does its job. What we have is a criminal justice system that disproportionately seems to only quote-unquote work when the perpetrators are not white. African American victims of homicide, by the way, make up most of the victims of homicide cases that go unsolved, whereas most homicide cases in which the victim is white, those get solved. In other words, crimes against white people are more likely to get solved than crimes against African American people or any other so-called minority group, a member of the global majority. And they're even more likely to get solved when the perpetrator of the crime happens to be African American. So in other words, if you're a white victim, you're more likely to get justice, and if you're a white perpetrator, you're more likely to escape justice. That's the system, and that's all that is evidenced by what he's saying. So when you look at the number of unsolved crimes, it's not unreasonable to assume that the, say, 60% or so of violent crimes in America that never get solved, that those are very possibly crimes committed by white people against African American people or against other so-called minority groups. So rather than saying blacks commit more crimes than anyone else in America, it would be more honest to say that no one who commits a crime in America is more likely to be punished for that crime than an African American. And in fact, it's also more likely for an African American person to be wrongfully convicted of a crime of which they are accused. And it's more likely for them to even be punished for that, even when they have been proven innocent. And you can look at the case right now of Marcellus Williams. So the statistics that he's citing actually only substantiate the belief that the so-called criminal justice system in the United States is a major component of what you can call a systematic domestic ethnic cleansing program in America, being carried out against African Americans and other members of the global majority. That's all that is evidenced by the statistics that he's citing. And this, in fact, demonstrates a vastly greater degree of criminality than anything that he mentioned. And I would go further to say that this speaker himself, with the statistics that he's mentioning and the interpretation that he's putting on those statistics, that he himself occupies a propaganda role in that ethnic cleansing system, for which, in my opinion, he could and should be prosecuted under international law. So I really would hope that people would take this more seriously and understand the gravity of what so-called minority groups, members of the global majority, what they are facing and what they are enduring, and the human rights violations that are committed against them in the United States, that you would take that more seriously, so that when you see someone who is clearly playing a propaganda role in support of what, again, does constitute an ethnic cleansing program in America, when you see someone who is occupying a role of propaganda in support of that system, normalizing that system, justifying that system, rationalizing that system, understand that this person is a criminal. And inshallah, one day they will face justice for that, and should not be regarded simply as someone who is airing offensive or controversial views. No, you should take this more seriously, and not simply use it as an opportunity to have a debate with someone like this. They shouldn't be debated, they should be prosecuted.
Okay.
Sure. Well, I mean, the violations by the United States within their own country and against their own people are multiple. And this is something that is unknown to most Americans because their oppression has been normalized for them. The injustice committed by their government against them and by the private sector against them has been normalized to where they think that it is perfectly normal, and that there's nothing wrong with it. But when you look at the actual statistics
For example, the statistics of violence in the United States, it's absolutely off the charts. The number of, what was it, 650, over 650 mass shootings just last year? 650 mass shootings. That's not 650 victims. That's 650 mass shootings with a mass number of victims in each one. You look at the number of people who are murdered by gun violence, just gun violence, not other kinds of violence. And you have plenty of different types of violence in the United States, but just by gun violence, the numbers are astronomical. It doesn't even compare to a war zone. The numbers don't even compare to a war zone. You'd be safer in a war zone. You'd be safer in a combat zone than you are in any American city, if you look at the numbers. And then if you look at the numbers of extrajudicial killings by the security forces, which is what you would call it if it happened in any other country, but when it happens in the United States, they just call it police shootings. And they can decide whether that police shooting is justified or unjustified, and just act like it was a mistake. Or they can do their version of exactly what the Israelis do when they decide to bomb a hospital or bomb a school or bomb a clinic or bomb an orphanage or just bomb a residential neighborhood. The Israelis will say there were terrorists there. That's their version of the same thing that the American police do when they decide to shoot an unarmed innocent person, when they say, oh, we thought that his phone was a gun, or we thought that he was armed, we thought he had a knife in his backpack, or we thought that pen he had in his hand was a weapon, we thought it was a gun, so we shot him. It's exactly what the Israelis do, and they learned it from each other. I mean, as we all know, many of the police forces in the United States are actually trained by the Israelis, or they do joint training with one another. I don't know who's teaching who, to be honest. But the number of police shootings, so-called police shootings, extrajudicial killings by the security forces in the United States was over 1,200 just last year. Over 1,200 of you, American citizens, I assume that many of the people who are in this live are American citizens, over 1,200 of you were murdered last year by your security forces who are supposed to be serving and protecting you. But instead of serving and protecting you, they're murdering you, and who knows, Allah forbid, but anyone who's watching this live may be next. Because this is what they do. You're supposed to be able to be protected from all of those gun violence, from all that gun violence, from those tens of thousands of people who are murdered every year in gun violence in the United States. You're supposed to be protected from that by the security forces. Instead, if you get in any danger in your neighborhood, if you're in the wrong neighborhood, and by the wrong neighborhood, everyone knows what I mean. I mean a neighborhood of people who don't look like me. I'm talking about a neighborhood of people who come from the global majority, people who are called minorities in the United States, even though they're members of the global majority. If you live in one of those neighborhoods and you get into any kind of a problem, if you're in any kind of danger, the last thing you want to do is call the police. If you call the police, the one who calls 911 is the one who's going to be ended up taken away in an ambulance because he got shot by the police. And you know what I'm talking about, and you know that it's true. This is the situation that you have in the United States, and it's systematic, it's systemic, it's organized, it's planned, because you can't look at the numbers, you can't look at the percentages with regards to victimization by the so-called security forces. You can't look at those numbers and think it's coincidental and think it's accidental. This is clearly systematic. The targeting of so-called minority communities, the so-called minority groups, and the so-called minority population in the United States are being targeted by the criminal justice system, being targeted by the prison industrial complex to be either shot, and if they can't shoot you, then they'll arrest you and they'll put you in jail, whether you're guilty or not. And we just saw what happened with Brother Khalifa Marcellus Williams, where the man was innocent, but they insisted to murder that man. The state insisted to murder that man. Well, in that particular case, that governor should be tried at The Hague. That's a crime against humanity. That's systemic, systematic, state-sponsored terrorism. And the same goes for your so-called security forces, your police forces, or what have you, that are sent out into the streets on a specific mission. And you can ask
You can ask any so-called minority, whether it's African American or Latino or what have you, who works for the police or who works in the corrections facilities, who works in any aspect of the criminal justice system, and if they've been doing it for some period of time and they're honest, they'll tell you exactly what I'm saying. They'll confirm for you exactly what I'm saying, which is that it is systematic, that it's planned, and that it amounts to a form of ethnic cleansing being carried out by the United States against their so-called minority communities. Members of the global majority are being targeted in the United States for extrajudicial killing and for incarceration, which then becomes slavery. Because once you're incarcerated, they put you to work, and you have to work for free, and you're working for private companies, for the profit interests of private enterprise. That's slavery, and you'll get a life sentence, so you're going to be a slave for the rest of your life. You don't even have a chance to be liberated from that slavery. At least in the old days, maybe there was a chance that you could escape. How are you going to escape from a maximum security prison? They've got you locked even more securely than if you had chains on your feet. This is the system that you have in the United States, and what you don't understand is that it's all a violation of international law. All of these statistics represent crimes, represent violations of the United Nations Charter, represent violations of the Covenant on Civil and Political Rights. It represents a violation on the Covenant for the Elimination of All Forms of Discrimination, racial discrimination. It represents violations of the Universal Declaration of Human Rights. For all of these things, the United States should be brought to the United Nations and should be subjected to sanctions, should be subjected to punishment by the international body, the one international body that is charged and has the mandate for the enforcement of international law. And those are just the most dramatic examples of the violations that only affect or disproportionately affect so-called minority communities in the United States. But all of you are affected. Every citizen in the United States is affected. Unless you're a millionaire or a billionaire, you're affected. Believe me. If you're a normal, average, working class citizen in the United States, you are hounded day and night by debt collectors, by bill collectors. You are living under the tyranny of your Social Security number and your credit report, which will determine what options you have in life. It will determine what you can own, what you can rent, or if you can rent, if you can get a job, if you can get a car, if you can get a house. You have a social credit system in the United States even more strict than they have in China. You pioneered it. China learned it from you, and theirs is more lenient than yours. This is all a violation of international law. They're not allowed to treat you like that because they made you poor. They're allowed to make you poor, but you're not allowed to be poor, apparently. This is a violation of international law. It's a violation, again, of the Covenant on Social and Political Rights. You don't even know what that is. You think the only law that applies to you is your Constitution. That's the only law that you think matters, the law of your state, and you have more laws in your country than any other country on earth, and you still call yourself the freest country in the world. You see how they've got your mind confused, how they've got you just turned around and upside down? You think you're the freest country in the world. Meanwhile, you have the most laws of any country in the world. You've got laws at the municipal level. You've got laws at the county level. You've got laws at the state level. You've got laws at the federal level. You've got laws inside the company that you work for. They'll decide whether or not you even get to go to the bathroom or not. You're subject to laws all the time, and your freedom is restricted drastically, and it's restricted in ways that are violations of international law. But they've got you, and they've kept you ignorant about what your rights are under international law. They want you to believe that when your rights are violated, or when you feel that your rights are violated, the only option that you have is to go for redress of your grievances to the one who's violating your rights. That's the system that they've set up for you. And you think it's normal. You think it's normal for it not to be safe to walk in the street. You think it's normal that you have neighborhoods in the United States where they have to put wood panels up against the windows because they're afraid of shootings, where people have to eat their dinner or eat their lunch have their meals sitting on the floor because they don't want to be within the range of flying bullets. You think that's normal. That's not normal. It's not normal. And it's not legal. This is what you need to understand. You're supposed to have recourse to international law. But the reason you don't have recourse to international law is because your country dominates the one institution that is responsible for the enforcement of international law. Unfortunately, the world's sheriff is an outlaw. And so that outlaw gets to do whatever they want. They've legalized their own crimes. They've legalized their crimes against you. And they've normalized in your mind being victimized by your country, being victimized by your government, being victimized by your state, being victimized by the very police officers who are supposed to be protecting you. But that's, again, that's not even the end of it. It's not even just about the police violence. It's not even about the violence that you are forced to live in on a daily basis in your American cities, but also even just something that you take absolutely as a given. You take this absolutely as a given, that they gather your data. They gather your personal data from all your devices, from all your computers and all your phones and whatnot. That they just gather it and there's nothing you can do about it. And they mass surveil you. Every single one of you is under mass surveillance. They watch your every move. They talk about China, but they're watching your every move. You tell me the last time you walked out of your house and took 5 steps and didn't see a CCTV camera. All of those CCTV cameras are connected to intelligence, they're connected to the police, they're connected to law enforcement and so forth. You're under their watchful eye every moment of your life. And that, by the way, is illegal. You have right to privacy. You have a right to your data. They don't have a right to take it from you. They don't have a right to collect it. They don't have a right to sell it. All of these matters have been determined and settled already according to international law, and America violates it every day because they know they can. Because they know that they dominate the United Nations. They dominate the one institution that, again, is charged with the enforcement of international law, which makes America above the law. That's one of the reasons why we're invoking Article 6. It's not just for the people around the world who are victimized by the United States. It's not just for everyone else around the world. It's for you too. Because you're never going to get your rights as long as you are under the boot of the United States, of your government, that doesn't even think that it has to treat you according to the law, because they think that their law is higher than international law. Well, they've got it backwards, and they've got it backwards in your mind, because you also think that if you're subject to international law, somehow that's against your interests, because you think American exceptionalism is for your sake. You're proud of American exceptionalism. But American exceptionalism only works if you're a millionaire or a billionaire or if you're in the government. Then it's only in your interests. But if you're a regular working class, rank and file American, American exceptionalism is the same, is the difference between being in general population in the prison or being in solitary confinement, where they don't have any cameras, where no one sees what they do to you, where you don't have anywhere to appeal. You can't talk to your embassy, you can't talk to your, you can't see a doctor, you can't see your lawyer. They've got you locked up in solitary confinement. That's what American exceptionalism means to the average American citizen in real life. That's nothing to be proud of. You should shake in your boots when anyone talks about American exceptionalism. This puts you in grave, grave danger. What it means is that America can treat you the same way it treats someone walking around in Baghdad, in Iraq. They can treat you the same way that they treat someone in Colombia. They can treat you the same way they treat someone in the Philippines. They'll treat you the same way that they'll treat anyone in the global south. Anyone in the so-called global south and the so-called third world and the developing world, the colonized countries, they'll treat you just like you're a colonized people. They'll treat you exactly the same way, and they look at you the same way, and they'll treat you the same way. And the only thing that can save you, the only thing that can liberate you from that domination, from that tyranny, is if America is expelled from the United Nations, and then the United Nations is liberated from American domination, and then they can take your country to the United Nations and impose rehabilitative, punitive punishment on your country and hold them to account and force them to adhere to international law.
All right. All right now. There you got it. What you think about that? Isn't that something? Let's take a break and we'll be right back. Yeah, hold on a minute. everybody, we're back. And now I want to deal with American law lessness. Lessness. Okay. We'll hear from this gentleman here, and I've been with him quite a while back in the past. Got a lot of information. He sued the state of Carolina and won. I mean, shook up the whole town. Nevertheless, I want to hear what he got to say today. American law. Hold on.
Talk shoes. Recorded live.
Hello, ladies and gentlemen. This is Rod. With recent discoveries of what we have found about the bankruptcy of 1933, the Social Security Act of 1935, Alien Registration Act of 1940, and the Federal Reserve Act of 1913. And the Federal Register, 1935, National Industrial Recovery Act, 1933, Executive Order 6174 by Franklin Delano Roosevelt. All this goes back in from 1913 from the Federal Reserve Act, was the intent to strip the American people of any lawful money by replacing it with Federal Reserve notes, which was from a private credit corporation from outside of the United States that Congress made a deal with. When the stock market crashed in 1929, this allowed them to point the finger that the United States government was not capable of handling its finances and that it was untrustworthy, and it needed someone to come in and control the financial world for them, which was a deal to steal everything off this country, including you, because you're listed as property in all your property that you have and all lands in this country. 1933 come up, they did the Public Law 148 Stat C1, where they turn around and they stripped the gold out of the people under penalty. They also passed that 49 Stat 3097 Treaty Series 881 Conventions and Duties and Rights of the State, putting this country under international law. They went in after they stripped the people of the money and placed us under international regulations. Because of the recession, depression at that time period, they passed the New Deal for administrative. They passed the National Industrial Recovery Act, which was to create jobs, but it wasn't to create jobs for the American people as what it was for the administration side. The Executive Order 6174 basically set up the administrative side of this thing for public works, for everything to come under administrative. The Federal Register allowed administrative committees and the president to come in and codify the statutes and place them under administrative rules, regulations, under administrative guidelines. As we are not part of that administration, they did not apply because it was purely administrative. Throughout the history and through the research that a lot of you have done, there's been so many pieces put in, but nobody has really been able to put all the pieces together on all of this. The history goes back in that we know that they're dealing with trust. All crimes are based on basic commercial crimes. Not saying that there are not legitimate murder, hit and run, You know, there are, but they're not being charged properly. Most crimes fall under commercial. Even though they set the Social Security up in 1935 to give the federal grant money to the states, every time the state reported a new birth, produced a certificate for that birth, federal government granted federal grants to that state for that birth certificate on name of that person. So what we're dealing with here, every charge that is being done in the court, it is the birth name that is being charged. Even though they are pulling the natural person in, the flesh and blood in, the charge goes back to that birth name, not to that natural person. This is where the concept and where the issue is coming in. Is they're dragging us in, but they're not telling us it's the birth name that's being charged, because that birth name being registered to the state and the state receiving federal grant money on behalf of, they have to find ways to use this money instead of using it on behalf of the people, so the state is embezzling it and the court system is embezzling it. And this is where the lawyers, the Bar Association, the judges, the courts, these people have, if we sit back and look, they have ran the biggest fraud on the American people in this country. Because you're getting nailed for a tail light being out or a license plate light out. There's no injury there, but they're charging you criminally for this. There's no corpus delicti. There's no injured party. The attorneys, lawyers, judges are wanting to play total ignorance. They just don't comprehend. They just don't understand. We just don't know what you're talking about. But yet, proven history has sit here and showed they're selling our signatures. And this is what McFadden got into in 1932 on the floor of Congress. It isn't the liquor. It isn't the material. It is the signature. It is that name that's being sold. It is that name that is being monetized. We have proven that in foreclosures, because the people coming in and going back and doing the research through Security Exchange, through Bloomberg, the fact that names used to come up on Dun and Bradstreet, used to come up on Fidelity whenever we used to have courts, and because we started exposing this, they have now started to take these offline so we cannot find them. Really what this comes down to is this. You've got a judge that sits on the bench that plays administrator. And a lot of people, what they're saying, this is probate court. And that technically, with what we're finding out, it's going right along. This is probate court. But they're not acknowledging any of this. It is total deniability on their side. But the fact that it is getting exposed, the truth of it is coming out. With what recent discoveries that we have made here, under Rule 19, under the Federal Rules of Civil Procedures, of other parties being brought in, indispensable parties being brought in. They're not being named. Whenever the police officer pulls you, tags you, IRS pulls you, tags you, whenever banker tags you, that indispensable party is not being represented in that courtroom in the open. And I'm using by in the open, they're not acknowledging it. They are not sitting here telling the client any of this. It is a secret that they have kept among themselves. They fail to disclose the whole proceedings of a courtroom. The prosecutor walks in, which is the attorney, representing the state, representing the government. He is really the trustee in this. The judge is the administrator. In order to relieve the burden off of the prosecutor or the attorney, the court has to appoint a lawyer somebody a friend. And this goes back into the history of what we've talked about here, ladies and gentlemen. There's no legislative law for lawyers. They've always been a friend. They've always been someone that was separate from the system, but yet part of the system. The attorney was actually part of the system. The judge is actually part of the system. So they brought in a third party, known as a lawyer, into these courtrooms. Throughout the years, they became bar members, and therefore, because they became bar members, they have now started to conceal a lot of the fraud, because stop and think, it is the lawyers and the attorneys. These are the ones that's creating the law. These are the ones that are creating the contracts. These are the ones who's writing all this stuff up. So they're setting things up knowing full well that they can walk in with pure immunity for not doing a job and being able to Shanghai and shake down the trust and swindle and embezzle out of that trust because of the way they worded these things. With what we have discovered here in the last few weeks and what we have talked about, it's about justice being blind. You have your unknown police officer out here being told to meet a quota. Go out here, do whatever you want to do, we'll cover you, we'll protect you, we will lie, we will protect you in any way we need. Even if you murder them, we'll call it self-defense because you was in fear of your life. They're not telling the police officer the whole thing of them, of this trust, where they are going in and tapping the trust and putting stuff on the stock market, and they are securitizing and filling their pockets. The judge is coming into this courtroom playing blind, deaf, and dumb. I'm using the word playing. They're not blind, they're not deaf, and they're not dumb. They know exactly what they're doing. They control that room. They control what comes into evidence, what does not. Every court case is pre-planned before the client walks in. All parties knows how it's going to go. Before it starts and before it ends, they already know what the game is. We have heard that these courts are nothing more than theaters. These are all actors putting on a good show. When the prosecutor is walking in, like I said, he is the trustee until they appoint a lawyer. That lawyer now is an officer of the court. He's an officer of the state. He now, the burden of the trustee from the attorney has now shifted over to the lawyer in that courtroom. And this is something they're not telling you. Through evidence of other cases, we have heard different things that has come back in and ties all this up. The moment you sit down and tell a lawyer that he's a trustee, they automatically want to quit. The moment you bring up a birth certificate into the courtroom, the judge automatically dismisses. So there are things that has popped up that has fueled this line of thought. It's the fact that that lawyer is acting as that indispensable party representing the state, which is the governor and the attorney general, the Social Security Administration, and the United States. He is actually representing that trust. He is the trustee of this. This is where the scam comes in. Is that lawyer does not put a defense up for the client. If he was to sit down and say, Your Honor, the prosecution here has the burden of proof, and he has to sit here and produce the corpus delicti, this would throw a monkey wrench. You will find that the attorneys and lawyers do not play this with each other. It's really coming down to where there is no laws or anything. It is just, he did, and your attorney admits, and you're crucified. These courts are a joke. There is no adversarial system in these courts. These courts are nothing more than hanging courts. When you're forced to hire that lawyer's coming in is representing the state, the Social Security Administration, and the U.S. government on that trust of your birth name. Because we have found in vital statistics under live birth that when it defines a person, it defines that person as a trust and as an estate and as property. It's corporations, it's partnerships. We are being tagged as partners in this when we're in that courtroom. Problem of it is, if we're partners, we're not being paid. Even a silent partner gets dividends off of his investments. You and I are not getting any dividends. That lawyer is intentionally and knowingly misrepresenting you in that courtroom because he is not bringing up any of the issues. He's not bringing up any laws. And the moment you talk to him about the laws, well, that's nonsensical. That's unintelligible. That's frivolous. I don't know where you're getting any of this. But yet when you sit here and you lay the books out, you sit here and show him Supreme Court rulings on decisions, and you sit here and show him American jurisprudence of decisions, and you bring out the statutes and you show decisions and legislative and terminologies and definitions, they don't want to go there. Well, that isn't how we operate. These aren't what we're running under. Well, what are you running under? That's what I was charged under. This is the definition for this charge. How does it apply to me? They don't want to go here. So the whole fraud comes down to this, ladies and gentlemen. Is that judge is the administrator in this. He's blind. The attorney represents the federal government, bringing a claim against the trust. He's the trustee. They have to give you a lawyer. That lawyer now takes the responsibility of that trustee. He now represents the state, Social Security Administration, and the U.S. government. Now, the prosecutor, the attorney, does not have to name the indispensable parties in that courtroom. Why? Because now that attorney assumes all three positions, but you're not being told this. They're not disclosing this issue. Whenever you come in and represent yourself because you're under that all caps, that judge is looking at you as that trust and as an estate, and therefore you are mute. Technically, yes, you are dead. He cannot hear you. So therefore, anything you say now comes into probate because your side has failed to show up. Your side has failed for proper representation. Now the state automatically gets it because we didn't know enough to go back and push the issue to bring ourselves in on an inner of appearance and make the separation between that all capital name being a ward or an estate or a trust or property. We did not know to make the distinction between us and that all capital name. So therefore, because we did not, we forfeited. And we got hammered anyhow. This is the scam that they're running on us, ladies and gentlemen. This is the scam. Eventually, this is going to come out. Eventually, what we're seeing here tonight, it's like their mortgage foreclosures. 4 or 5 years ago, we was bringing this stuff up, and so was other people. And now we're seeing the securitization. What was said 4 or 5 years ago is now coming out to be the truth. That's the same thing with this. The time's going to come with what we're broadcasting here, that the judge is playing administrator. The attorney is the trustee for the state. The administrator has to appoint opposing counsel to represent the state, the Social Security Agency, and the United States. He has to appoint the indispensable parties in order to steal out of the trust, in order to embezzle. And then the attorney steps off to the side and pats you on the back, or motions to the judge, points over to you. We, not knowing, accepted, and we now took that responsibility as that secret partner in this case, which now we became liable. This is the fraud. This is how simple it is. A lot of you people have been out here. You've come so close, but there's pieces that you are missing. I am putting this out to you for you to think about with what you've already discovered, with what we've discovered, is that the court system is nothing more than a sham. It's nothing more than a kangaroo setup. The judge is nothing more than playing administrator. The prosecutor is nothing more than the trustee. And then the administrator has to appoint another trustee to cover the government, to make it look legitimate, make it look like there is some type of integrity in this courtroom, but there's no integrity at all. Because when that lawyer gets appointed, like I said, they're not telling us that he is taking over that indispensable party. They're not telling us that the state should have been named as a defendant. The Social Security Department should have been named as a defendant. And the United States government, under the United States of America, should have been named as a defendant, as indispensable parties. They are always leaving these three out in every single court case. This is why they appoint that attorney, or that lawyer, excuse me. That's why they appoint that lawyer. That lawyer takes all three positions, unbeknown to us until now. Time will come. This will be exposed. But we're putting it out now for people to think about. Because like it got put out about the foreclosures, about the embezzling, about the securitization and the selling of your signature. This is what exposed the banking fraud. We start getting this message out now that that judge is acting as an administrator, playing blind, deaf and dumb here, and the attorney representing the United States, representing the trust, wants to embezzle out of the trust. But in order to do this, they have to appoint a lawyer to make it look legitimate. And then bring him in as the indispensable three parties here of the state, the Social Security agent, and the U.S. government. He doesn't put up a defense. He pleads guilty and then shifts the burden over to you as the silent partner for you to take the fall so they can sit here and strip your trust account under that birth thing because it's got money in it, so they can put it in their own private account. This is how simple this thing has come down to. This is how simple it has come down. And it's taken us a long time, but because of different people who have come out and did different things, because of results of what they've done, has allowed these pieces to fall together with what we're explaining now in these courts of what they've done to us, what they're doing to us, and how they're doing it. We need to start coming in as that third-party intervener into this thing, or that third party of interest. We need to make the distinction between that name that's on that docket or on that court filing as being a ward or an estate or a trust. And we need to start asking, is it not the birth name that's being charged in this courtroom? Is it not the birth name that's being charged? And if you can have your birth certificate with you, bring in your birth certificate, says here is the birth name. This is what's being charged. Is it not true that you're charging the trust? Is it also not true that you should be naming the indispensable parties, such as the state, which would be the Attorney General and the Governor? Should not be naming the Social Security Administration, as they are the ones who give the federal grant to the state, to the Attorney General, and to the Governor, that they are the receivers and trustees of this birth name? And should not the United States of America be also brought in here as an indispensable party? Is this why you want me to have a lawyer, because he's now taken their position? Ladies and gentlemen, we need to start hitting these courts up on this, point blank. Because all these crimes are commercial. And for what we've learned here off this federal jurisdiction video, everything falls under banking, falls under trust law. Everything falls under corporations, falls under partnership. This is why they define a person as a partnership. Because under that birth certificate, under the bankruptcy of 1933, the state is the administrator and the trustee. We were supposed to be the beneficiaries of this, but they made themselves the administrator. They made themselves the trustee. They have made themselves the beneficiary of this, because you and I are not getting anything. Our bills are not being paid. Our schools are not being paid. We're still being charged taxes for the property. We're being charged taxes for the vehicles. We have to pay for everything with phony money. Ladies and gentlemen, this is the biggest scam that has ever been ran. And we need to start challenging this in the court. Is it not true that you're charging the birth name? Is it not true that that birth name is a trust? That birth name is not listed as a flesh and blood. Isn't it true that it's listed as a trust and an estate and as a partnership? And this is what you are charging. Then why did the prosecutor not sit here and bring in the indispensable parties, which would be the state where that birth name is registered, the Social Security Administration, and the United States government? Is this why you want me to have a lawyer? Is because he takes all three of these and he's going to plead guilty? We need to start bringing this kind of stuff up in a courtroom, ladies and gentlemen. We need to hit them point blank with this. This is something that needs to be done. Because now they don't have an answer, because they cannot prove, because they do not have a corpus delicti. If you did not murder anybody and you did not damage anybody's property, but you are being drugged in here for seatbelt violation, you're being drugged in here for doing 35 and 25, and there was no damage, there was no threat, no harm. You're being drugged in here because you had a tail light out or a headlight out, you didn't use a turn signal, nobody was harmed. These are all commercial crimes. Well, you didn't pay your taxes. That's all commercial crime. It's that birth name that they're charging, because that birth name is a trust. That birth name has grant money tied to it. Think about what we're talking about here today. Think about what we're sitting here saying. We need to start cornering these courts and start bringing this issue up. start demanding who is the corpus delicti, because that corpus delicti goes two ways. One, they have to produce who was harmed, who was injured, and who is being named. And what is the dollar amount value attached to this? Because this is what this guy was getting into in part one of that federal jurisdiction under the 12b-6. Because you failed to state a monetary value, because you and I are not in the beneficiary position of this trust. Therefore, that trust name is the monetary side. The living man, the living woman is not the monetary side, because we're not receiving any benefits from it. Think carefully about what we're talking about here. Think back and think carefully about what we're talking about. You and I are not receiving any benefits. You and I are not receiving anything out of that trust. But the state is. They are the administrators, they're the trustees, and they are the absolute beneficiaries of it. And when we walk, they want to make us a partner. And that's exactly what that lawyer does. He turns around and sits down. Here's the partner. I'm no partner. I haven't got anything out of it. I have not got a dime. The lawyer is the trustee in this. He's the one that's receiving. You want to see how fast he shoves this back over to the prosecutor? This is just a little simple thing here tonight we're talking about. There's not a whole lot of detail. We're just putting out for a line of thought for you to sit here and think about how they're running the courts. And the biggest scam that's ever been perpetrated on the American people in this country. And it's taken us a lot of years to figure it out. It's taken us a lot of years to figure it out. But now we've got it right down to where, because we know for a fact the birth name is a trust. We know for a fact that that birth name does receive money on federal grant. The state receives it. It is an absolute proven fact. It's in the laws. Their laws. They wrote them. It is an absolute fact that that birth name is a trust, because it is written in their laws. So this judge is doing nothing more than sitting there as a mediator, nothing more than an administrator, allowing the state to represent the trustee. And when we get brought in and we don't distinguish the difference between that trust name and our intervener self in this thing, or party of interest, the court looks at this as if we never showed up. So they walk right over us. That's why they don't accept anything, because we did not enter our appearance in. That's why they want to give us an attorney. That attorney sits here and represents state, Social Security, and the United States government. But they don't tell us this. I said I'm going to keep this short, about a half hour. That's all we need. Like I said, think about what's being said here tonight. Thank you. Good night.
All right, everybody, we back. That was Mr. Rod Clare. What you think about them apples? Now, I want to deal with the underbelly. We went all the way back to the beginning, come all the way up to the 21st century. But let's look at the moral side of America. And what is the historicity of how they have dealt with women? How they view them in the United States. Let's deal with that part. This will be my final part here. And we'll go on down into our closing. So y'all hold on a minute. Let's check out this thing here Mr. Bolson has to say about this.
The West is misogynistic and always has been. And I mean that according to the dictionary definition. They hate women, truly. There's no other culture or civilization in history, in my opinion, that degrades and belittles women as much as the West. They objectify women so profoundly that women in the West objectify themselves.
They used to wonder, whether or not women have souls. And it seems like they ultimately decided that they don't. Women are nothing to them but bodies. Women are nothing but bodies in Western culture. They're decorations. Women's bodies are supposed to be part of the scenery, nothing but props. That's why you can even have this absurd debate about what a woman is, because if she is nothing but a body, which is what she is in the West, if she's nothing but, lipstick and breasts, hips and a hairdo, then she can be replicated. A man can make himself look like that. He can do a convincing performance, an exaggerated impression of what a woman is, a lampoon. He can do what's essentially a gender minstrel show. Instead of blackface, it's lipstick and makeup and a wig, plus some hormone injections. Because they really think that that's all that women are, and that's all they want women to be. That's what they want women to be, because that's what they reward women for being. I mean, I saw a report that's a few years old, but it showed that strippers make as much money as a lawyer on average. Now, in a materialistic culture of commodification like the West, it's easy to see what the society approves of and what they value, because that's who gets paid. So when you send a message to women and to girls that wealth can be rapidly expedited for them if they take off their clothes on stage or on camera, rather than develop their minds, rather than develop their skills, their character, and so on. When you tell women and girls that you're going to have to go to university for years, you're going to have to be in the workforce for years before society will monetarily reward you anywhere close to what it will reward you right now, today, if you will just objectify yourself and get naked in front of strangers. The message is crystal clear. We want you to be what we think you are, which is a sexual object. And if you'll go along with that, you will be generously rewarded. We don't think you have dignity. We don't think you have honor. We don't think you're decent. We think that you're agents of the devil and instruments of sin. You caused the fall of man. That's deeply embedded in the cultural thinking of the West. And clothes, being covered, covering your nakedness, is only for the dignified. That's why they strip you in interrogations, to break you down, to humiliate you, to demean you, to create an imbalance of power between you and the interrogators. I know what I'm talking about because they did it to me. They do it to make you vulnerable. Well, that's what the Western society does to women. Forget about slut shaming. They practice modesty shaming, virtue shaming, dignity shaming. Because who are you to think that every man in the public sphere isn't supposed to be able to see your body? What makes you so special? What makes you think that you have the right to deny any man's eyes access to your body? Your bodies are supposed to be public. Your bodies are supposed to be decorations. That's the culture. And they don't want dignified women in the public sphere. They don't want virtuous women in the public sphere. They don't want modesty. So now France has banned women from wearing abayas in schools. Women can't wear clothes in schools that deny male teachers and fellow students access to enjoy their figures, to enjoy their bodies. And of course, this is just a crooked way of banning Muslim women from education. Just like the public ban on the niqab, France wants Muslim women to stay in their homes, and they don't want them to go to school. In other words, they're not allowed to be in public, they're not allowed to go to school, unless they go along with your objectification and misogyny. Because Muslim women destroy your narrative about women, and that's unacceptable to you. Muslim women destroy your vindictive understanding of patriarchy, and that destroys your whole narrative about Muslim men in the process, and by extension your whole slanderous narrative about Islam. Because like I said before, in Islam, men have authority over women, and we don't say that that means superiority over women. It's absurd to pretend that the Muslim world is misogynistic on any scale like the West, especially with regards to the issue of hijab. I mean, I don't think there's any better argument against the claim that hijab is a manifestation of male domination than the advertising industry. I mean, think about it. Companies know, and have known for a very long time, that men like to look at women's bodies. In fact, there isn't anything that men would rather look at than women's bodies. As much as they might like hamburgers, they would rather look at an advertisement of a beautiful woman in a bikini holding a hamburger than to look at the hamburger itself. That's why you use women in advertising the way you do. In a male-dominated society, women would be less covered, not more covered, because, well, that's what men want to see, and in a male-dominated society, they control the norms. And this should be understood. In a male-dominated society, in a truly misogynistic society, men believe that it is their right to see women's bodies. If a woman is covered, they feel deprived. The covered woman is defying their entitlement. You can even decipher this in their anti-hijab arguments, when they say that hijab seeks to make women invisible in the society, as if a woman isn't there if you can't see her legs or her hair or the contours of her body. She just doesn't exist if she's not showing you her body. This kind of pseudo-feminist assertion objectifies women even more than the hamburger advertisement that just uses a woman to sell meat. If she's not presenting herself as a decoration on the street for the appreciative eyes of passing men, then she's a non-entity in the West. Whereas a man in baggy trousers, a jacket, and a hoodie, where only his hands and his face can be seen, he's not vanished from the society. Just because you can't see his skin, he's still there. Because men's role in the West is not decorative, women's is. And that passes in the West for female empowerment. I don't know what's so difficult to understand about the connection between conforming with what gratifies men and being therefore dominated by men. And I don't think anyone wonders whether men are more gratified by seeing a scantily clad woman than seeing a woman in the hijab. I mean, whose image is more likely for men to search on Google, Kim Kardashian or Afghan woman in a burqa? No, the West hates Muslim women because they embody the antidote for the poisonous narrative that the West has always maintained about women. And they're afraid that women will catch on. They're afraid that their own women will start to realize that they don't deserve to be stripped down in public and objectified, that they don't have to suffer all these body image issues, you know, the eating disorders, the depression, the anxiety over whether or not they can fit into a tight dress or a short skirt to conform with societal expectations. They're afraid that Muslim women will make their own women question their own self-objectification, and then the party will be over. That's what they're worried about. And they're not wrong. Women convert to Islam twice as much as men. That's that many more women whose bodies you won't be able to consume with your eyes anymore. That's that many more women who want to be dignified and don't want to be decorations. Yeah, this is something I've been wanting to talk about for a while, actually. And France just gave me a good reason. You know, there's more to talk about than we could really get into today. But let me just sort of skim the surface of the topic. The West is misogynistic and always has been, and I mean that according to the dictionary definition. They hate women, truly. There's no other culture or civilization in history, in my opinion, that degrades and belittles women as much as the West. They objectify women so profoundly that women in the West objectify themselves. They used to wonder, you know, whether or not women have souls, and it seems like they ultimately decided that they don't. Women are nothing to them but bodies. Women are nothing but bodies in Western culture. They're decorations. Women's bodies are supposed to be part of the scenery, nothing but props. That's why you can even have this absurd debate about what a woman is, because if she is nothing but a body, which is what she is in the West, if she's nothing but, lipstick and breasts, hips and a hairdo, then she can be replicated. A man can make himself look like that. He can do a convincing performance, an exaggerated impression of what a woman is, a lampoon. He can do what's essentially a gender minstrel show. Instead of blackface, it's lipstick and makeup and a wig, plus some hormone injections. Because they really think that that's all that women are, and that's all they want women to be. You know that's what they want women to be, because that's what they reward women for being. I mean, I saw a report that's a few years old, but it showed that strippers make as much money as a lawyer on average. Now, in a materialistic culture of commodification like the West, it's easy to see what the society approves of and what they value, because that's who gets paid. Conformity with expectations is monetized, it's rewarded. So when you send the message to women and to girls that wealth can be rapidly expedited for them if they take off their clothes on stage or on camera, rather than develop their minds, rather than develop their skills, their character, and so on, when you tell women and girls that you're going to have to go to university for years, you're going to have to be in the workforce for years before society will monetarily reward you anywhere close to what it will reward you right now, today, if you will just objectify yourself and get naked in front of strangers. The message is crystal clear. We want you to be what we think you are, which is a sexual object. And if you'll go along with that, you will be generously rewarded. We don't think you have dignity. We don't think you have honor. We don't think you're decent. We think that you're agents of the devil and instruments of sin. You caused the fall of man. That's deeply embedded in the cultural thinking of the West. And clothes, being covered, covering your nakedness, is only for the dignified. That's why they strip you in interrogations, to break you down, to humiliate you, to demean you, to create an imbalance of power between you and the interrogators. I know what I'm talking about because they did it to me. They do it to make you vulnerable. Well, that's what the Western society does to women. Forget about slut shaming. They practice modesty shaming, virtue shaming, dignity shaming. Because who are you to think that every man in the public sphere isn't supposed to be able to see your body? What makes you so special? What makes you think that you have the right to deny any man's eyes access to your body? Your bodies are supposed to be public. Your bodies are supposed to be decorations. That's the culture. And they don't want dignified women in the public sphere. They don't want virtuous women in the public sphere. They don't want modesty. So now France has banned women from wearing abayas in schools. Women can't wear clothes in schools that deny male teachers and fellow students access to enjoy their figures, to enjoy their bodies. And of course, this is just a crooked way of banning Muslim women from education. Just like the public ban on the niqab, France wants Muslim women to stay in their homes, and they don't want them to go to school. You say that that's what we force on women, but because we don't actually force that on women, now you're trying to enforce it yourselves. France is enforcing it themselves. You don't want Muslim women in public. You don't want Muslim women to get an education. It's not us, it's you. You're the one who's trying to prevent them. They don't want you to go to school, Muslim women to go to school, unless you abandon modesty, unless you compromise in your values. In other words, they're not allowed to be in public, they're not allowed to go to school, unless they go along with your objectification and misogyny. Because Muslim women destroy your narrative about women, and that's unacceptable to you. Muslim women destroy your vindictive understanding of patriarchy, And that destroys your whole narrative about Muslim men in the process, and by extension your whole slanderous narrative about Islam. Because like I said before, in Islam, men have authority over women, and we don't say that that means superiority over women. It's just a function. It doesn't mean, for us, it doesn't mean keeping women down. It doesn't mean oppression. It just means more responsibility for men, a duty to protect and to provide and to help and to support and to preserve respect and dignity and to ensure that they will not be objectified and demeaned by every Tom, Dick, and Harry, or every Francois, or Jacques, or Emmanuel. It's absurd to pretend that the Muslim world is misogynistic on any scale like the West, especially with regards to the issue of hijab. I mean, I don't think there's any better argument against the claim that hijab is a manifestation of male domination than the advertising industry. I mean, think about it. Companies know, and have known for a very long time, that men like to look at women's bodies. In fact, there isn't anything that men would rather look at than women's bodies. As much as they might like hamburgers, they would rather look at an advertisement of a beautiful woman in a bikini holding a hamburger than to look at the hamburger itself. That's why you use women in advertising the way you do. In a male-dominated society, women would be less covered, not more covered, because, well, that's what men want to see, and in a male-dominated society, they control the norms. And this should be understood. In a male-dominated society, in a truly misogynistic society, men believe that it is their right to see women's bodies. If a woman is covered, they feel deprived. The covered woman is defying their entitlement. You can even decipher this in their anti-hijab arguments, when they say that hijab seeks to make women invisible in the society. As if a woman isn't there if you can't see her legs or her hair or the contours of her body. She just doesn't exist if she's not showing you her body. This kind of pseudo-feminist assertion objectifies women even more than the hamburger advertisement that just uses a woman to sell meat. If she's not presenting herself as a decoration on the street for the appreciative eyes of passing men, then she's a non-entity in the West. Whereas a man in baggy trousers, a jacket, and a hoodie, where only his hands and his face can be seen, he's not vanished from the society. Just because you can't see his skin, he's still there. Because men's role in the West is not decorative, women's is. And that passes in the West for female empowerment. I don't know what's so difficult to understand about the connection between conforming with what gratifies men and being therefore dominated by men. And I don't think anyone wonders whether men are more gratified by seeing a scantily clad woman than seeing a woman in the hijab. I mean, whose image is more likely for men to search on Google, Kim Kardashian or Afghan woman in a burqa? No, the West hates Muslim women because they embody the antidote for the poisonous narrative that the West has always maintained about women. And they're afraid that women will catch on. They're afraid that their own women will start to realize that they don't deserve to be stripped down in public and objectified, that they don't have to suffer all these body image issues, you know, the eating disorders, the depression, the anxiety over whether or not they can fit into a tight dress or a short skirt to conform with societal expectations. They're afraid that Muslim women will make their own women question their own self-objectification, and then the party will be over. That's what they're worried about. And they're not wrong. Women convert to Islam twice as much as men. That's that many more women whose bodies you won't be able to consume with your eyes anymore. That's that many more women who want to be dignified and don't want to be decorations. The West has been at war with women's self-esteem and self-respect and against their value as human beings for as long as anyone can remember, throughout their entire history. And the more so-called liberal it becomes, the more that war intensifies. The more so-called feminism spreads, the more vulnerable and exploited women become, until you actually start saying that OnlyFans girls are empowered women, feminist role models, because they embrace the norms of sexual objectification to game the system and make money. I'm telling you, you're sick. It's deranged. And the presence of Muslim women in the public sphere in the West undermines all of that. It spreads a cure for a disease that you don't want cured. And France is one of the worst infected. It's one of the most misogynistic and least civilized countries in Western society, and one of the most cowardly. So it's not surprising that they'd be scared of Muslim women. And of course, they're getting kicked out of all of their former colonies in the Muslim world, so that doesn't help. I mean, they were ordered just a few days back to leave Niger in 48 hours, and they stamped their feet and clenched their fists and said Niger had no authority to tell them to leave. So Niger turned off the electricity and the water at the French embassy. So they're feeling impotent. They're feeling emasculated. And typically in the West, and in France, they assert their manhood by oppressing women. But all anyone sees from this is just a display of weakness, an erosion of imperial ability. I mean, think about it. School is largely about indoctrination, and French schools have apparently failed to indoctrinate Muslim women sufficiently to get them to uncover themselves. So now you have to ban the abaya. You couldn't convince them to take off the abaya through years of state-funded indoctrination in the school system. That means your ideology is losing influence in your own country, in your own institutions. So then you have to resort to force. Well, this approach, the resort to force, is always a prelude to defeat. If the French establishment can be threatened by a piece of fabric, well, how the mighty have fallen. So now sisters in France find themselves in a position similar to the position of sisters in Afghanistan. How ironic. Emmanuel Macron became a mullah, except he doesn't have the guts to just be straightforward about it. Like with everything else, they have to do it sideways. They can't be direct. But what it comes down to is they don't want Muslim girls in school. They don't want Muslim women in school. They don't want Muslim women to be educated. They don't want Muslim women in public. Now, at least the Taliban, they have the excuse that their country has been at war for half a century, and they want to stabilize the situation, check the curriculum and so on. So they have some excuses for why they're doing it. But France is doing it because they're falling apart without a war. Their civilization, their culture is imploding. It's collapsing because it just isn't strong enough to stand. And their culture and their civilization has not provided them with any way ideologically to make it stronger. So at this point, every move they make is the wrong move. Every move they make just compounds the weakness. I mean, I'm sorry for sisters in France who have to deal with this. And I hope that you won't compromise. I mean, anything that you're going to learn in those schools, you could learn from home anyway. And I would tell the sisters in France that you are already greater teachers than your instructors in those classrooms. And the lessons that you are teaching to the people of France, to the society of France, by your continued compliance with the dignity and the modesty of Islam, those are far more important and far more beneficial lessons for your society than anything that they want to teach you.
Okay, we're back, and we're going to go on down to the final segment. I won't be able to run all this, but I got to run some of it because we're trying to expose as much as we can about a subject you already know who and how to sue. Mr. Rock Class and told you that. And let's see, did I? Wait a minute. Let's see, I ought to miss them.
The U.S. Constitution is made up of 7 articles, or sections, and Article 4 plays a critical role in defining the relationship between the states and the federal government. It outlines the framework for cooperation among the states and ensures that the rights and responsibilities of each state are respected across state lines. For many people, Article 4 is the forgotten section of the U.S. Constitution, and it really shouldn't be. Most people know Article 1 pertains to the legislative branch and lawmaking process. Article 2 is about the executive branch and the role of the president. And Article 3 vaguely, almost mysteriously, discusses the judicial branch and Supreme Court. Article 4, on the other hand, is like the end of an episode of Unsolved Mystery. If you or anyone you know has information of the whereabouts of Article 4 of the U.S. Constitution, or what it pertains to, write to us at... But it's not so mysterious when you think about what the framers of the Constitution were trying to set up. Let's go back in time. The year is 1787, and the U.S. has officially been a nation for just over a decade, and things aren't going so great. Actually, that's an understatement. Things are going very badly, and a lot of that has to do with the very weak central government, set up by the first governing document of the nation, the Articles of Confederation. Look, this thing was a train wreck. Under the Articles of Confederation, we only had one branch of government, which was the legislative branch. That means no president and no Supreme Court. Let that sink in for a minute. Only a lawmaking body with no leader to enforce laws. That's like writing the rule, take one, on a bowl of Halloween candy and just leaving it on your doorstep with no one to enforce the rule. We all know how that turns out. Remember, the writing of the U.S. Constitution was the Hail Mary of a failing Confederacy. The last attempt to save a sinking ship of a nation from crumbling under unpaid war debts, rising inflation, and the lack of a standing army. So, along comes this plan to beef up the central government, adding power to the legislative branch because that was the only branch of government under the Articles of Confederation, and then adding 2 other branches, the executive and judicial, so that the central government had authority to make states do things, like pay their taxes, and respect the laws of other states. Remember, states were pretty unfriendly to one another before the Constitution. Under the Articles of Confederation, it was common for states to impose heavy taxes on the other states' goods. They also had trouble converting one another's currency. I mean, how many Massachusetts dollars equals a New York dollar anyways? They could refuse to recognize legal documents from one another, and if disputes really got out of hand, could declare war on one another. So, yeah, giving the central government more power to make the states behave was needed for this new struggling nation to actually survive. But there was a concern for what would happen to the states. Would they no longer have authority over anything? With this new constitution, would this be tyranny again from an impressively strong government? Well, Article 4 of the Constitution helps answer these questions and many more. It's broken down into 4 sections, so let's do a quick rundown. Section 1, known as the Full Faith and Credit Clause, mandates that each state must recognize the public acts, records, and judicial proceedings of every other state. In other words, if you're legally married in one state, you're married everywhere. Section 2 deals with privileges and immunities. This section ensures that citizens of each state are entitled to the same privileges and immunities as citizens of other states. It means, for example, that a person moving from one state to another should be treated fairly and equally. A state couldn't make a law or enforce one that treats someone from another state in an unfair way. Article 4, Section 2 would make this law unconstitutional. Section 3 covers new states and territories. It outlines the process for admitting new states into the Union and governs the creation of new states from existing ones. 37 states have been admitted to the U.S. under Article 4. Vermont was the first in 1791. Hawaii the most recent in 1959. Now, most states were first organized by Congress as federal territories before they were admitted as states, but Article 4 doesn't require this. Take Texas, for example, which was an independent republic before it was annexed by the U.S. and admitted as a state in 1845. Finally, Section 4 addresses the Guarantee Clause. It ensures that every state will have a republican form of government, and be protected against invasion and domestic violence. This clause underscores the federal government's role in maintaining order and democracy, making sure all states have the same or similar form of government, and that the central government will protect the states against invasion. The main purpose of Article 4 is about states and how they should behave, specifically with each other. But Article 4 also establishes the concept of federalism. And in this system of government, the central and state governments share powers and responsibilities. A key point is that they share powers, not that those powers are equal. This is a pretty common misconception about the federal system of government, and one that you don't want to make. So, when Article 4 says that states are guaranteed to be protected from invasion, this is defining powers that are specific to the central government. But federal systems of government also give powers to the state governments, allowing them to manage more local responsibilities. Now, if I asked you, which government do you think has more total powers and responsibilities, which would you think it is? Well, I just told you that they're not equal, so throw that answer out. And it's not the federal government. State governments actually have more powers and responsibilities than the central government. And it makes sense when you think about it. So, the central government is greatly concerned with big picture stuff, like defending the nation, international affairs, coining money, and citizenship. These issues are so critical and so important that the central government feels no one else should be doing this. And rightly so. Things could go very badly if states could coin their own money or declare war on other countries. So for powers that are dedicated only for the central government, we call these enumerated powers. And enumerated essentially means that they're listed or written down somewhere, that being the Constitution of the United States. Because it is written there, it is for the central government and no one else. But aside from these major responsibilities, the central government is much less concerned with everything else, leaving the majority of the responsibilities for the state governments to take care of. That means everything else is handled by the states. Powers that are only for state governments are known as reserved powers. This list is the best example of reserved powers, but man, are there a lot of them. Think about it. If it's not written in the Constitution, and there's only 4 or 5 powers that are written in the Constitution for the central government only, then it's saved or reserved for the states to handle, and that's a lot of things. Now, reserved powers is more in reference to the 10th Amendment, or change to the Constitution, but we might as well talk about it right now. In the 10th Amendment, it mentions that if a power is not specifically given to the central government, and it's not specifically prohibited for the states to do, then this is a power that is saved or reserved for the states. So the 10th Amendment is basically defining this federal system of government without actually using the word federalism. You know, come to think of it, Article 4 of the Constitution also does not mention the word federalism. Okay, so here's another question for you. If Article 4 of the Constitution sets up the federal system, is the 10th Amendment redundant? The answer is yes and no. Remember, in order to ratify the Constitution of the United States, the anti-federalists, the ones who were not so happy about what they saw in the document of this powerful central government, wanted some assurances. They wanted some guarantees that there would be some changes made to reduce the power of the central government. So the Federalists promised to make a list of changes. We call them the Bill of Rights, right? The first 10 amendments or changes to the Constitution that would further limit the power of the government by giving the individuals more rights. The 10th Amendment simply pumps up the power of the states and guarantees that they will have their own authority concerning matters that are saved or reserved for states only. Okay, that's the end of the detour. Shall we continue? There's really only one other thing to mention about Article 4, and that's the fact that the central and state governments can also share a power. These shared powers are known as concurrent powers. The best example I can give of a concurrent power would be the power to tax. This is not a power that solely belongs to the central government or solely belongs to the state government. Both of these governments need to do these things in order to fund their government responsibilities. So there you have it. Article 4 sets out to explain how states should behave with one another. It establishes a federal system by stating the central government will take care of the big picture stuff, leaving most everything else up to the state governments. and by doing so reinforces the concept of limited government, which is what we love here in America. Okay, I can see it in your eyes. You're wondering, how does establishing a federal system actually limit the power of the government? When we take all of the powers that a government can do and we divide it, we're actually reducing the power of both. If you can imagine taking all of the powers of the central government and the powers of the state governments and combining them, all of a sudden we have a very authoritative, very powerful government, and this is something that we don't want. A federal system inherently limits the power of the government simply by dividing the powers between the federal or central government and state governments. Okay, that's it for now. Thanks so much for sticking to the end of my video. I hope you enjoyed it. I hope you learned something. We'll make more videos soon. With the 2024 general election sure to be an absolute disaster on election night, many Americans will ask themselves, is this how elections are supposed to be run? And if so, what were the Founding Fathers thinking? The short answer is yes. This is how elections are supposed to be run. But the real question that should be asked is, where in the Constitution does it say all of this? And that is a more complicated question to answer. Let's dive in. The Constitution of the United States of America contains just 4,500 words. To give you some perspective, Dogman has 5,035 words. Dogman. The document is vaguely worded and does not go into a lot of detail. The framers of the Constitution wrote it this way purposefully because they weren't really sure how this new government was supposed to work. The only thing they were confident about was that the new government established by this Constitution needed to be stronger to handle the major failings of the nation going on at the time. Just a few things, really. Other than that, the nation was operating like a well-oiled machine. So, the new Constitution is drafted with the understanding that what we thought was a good idea of how to run a government in the Articles of Confederation turned out to be an absolute train wreck. And what we have planned now to be a functioning government might also not work so well. So the document is vaguely worded, somewhat mysterious, needs a lot of interpretation, and has an emergency "we need to change something" button in the amendment process. Voting and elections were not exactly at the forefront of conversation at the Constitutional Convention, since so many other pressing issues were on the minds of the framers. In fact, the Constitution doesn't have much to say about the right to vote. Nowhere in the text does it explicitly say that citizens have the right to vote in elections. Yikes! But here's what they wrote down in regards to the matter of presidential elections. Article 2 of the Constitution deals with the newly added branch of government, the executive branch. Yes, the framers' fear of another king, a singular tyrannical ruler of the government, was so profound that they omitted the position of an executive leader in their first attempt at a constitution. But in their second attempt they realized somebody's got to be in charge. Someone needs to enforce the rules, and someone needs to be responsible and to blame when things go bad. In Article 2, Section 1, Clauses 2 and 3, it states, "Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector." This is the wonderful introduction to the Electoral College and how they will be selected by...
Okay, everybody, we come down to the close of the broadcast, and no one will be able to get it all in. And I seem to have missed something. I think I got thrown off a little bit today. But nevertheless, we're coming back with some more later on down in the week. But I've been your host, Tarhaka, on my next
Fire, flood, tornado, hurricane. The damage they can cause to your home is devastating. But there's another disaster that strikes when you least expect it. I'm talking about your own insurance company when they deny your claim. If you believe your homeowner's insurance isn't paying what they should, let the lawyers at Farah & Farah review your policy word for word for free. Farah & Farah, here for you, here for good. Jacksonville.
How to have fun, anytime, anywhere. Step 1. Go to ChumbaCasino.com.
ChumbaCasino.com. Got it.
Step 2. Collect your welcome bonus.
Come to Papa welcome bonus.
Step 3. Play hundreds of casino-style games for free.
That's a lot of games. All for free?
Step 4. Unleash your excitement.
Chumba Casino has been delivering thrills for over a decade. So claim your free welcome bonus now and live the Chumba life. Visit ChumbaCasino.com.
VGW Group. No purchase necessary. Void where prohibited by law. See terms and conditions. 18+.